Good morning.
Good morning, Honorable Judge.
Sorry for the brief delay in joining the the hearing. Uh, Hang on just one second. Okay. So I have several matters on the calendar this morning. First up is if you're here on the Shine Investments matter, apparently everybody was reset. I don't see anybody I recognize from that case, so apparently everybody got the notice. Mr. Jarvis?
Yes.
Um, so my understanding is that we received a notice of withdrawal accompanied by a proper certificate in motion, seeking to withdraw on behalf of Shine Investments. Also, at once receiving that and noting that Mr. Henderson asked for an extension of, I think, 30 days so that his client could retain new counsel. And what my staff also noted was that probably ought not to have been on this calendar anyway, because the brief discovery period had been set, I think, through March 9th. And so it was an open question. Forgive me for not knowing off the top of my head, Mr. Jarvis, but tell me where you fit in this.
Yes, I represent Shine.
Okay. Well, I appreciate your appearance then. Did I get all that right?
Yes.
Okay. So what I expect will happen, as I said, is that we will enter the order of withdrawal of Mr. Henderson's firm, and then we will reset those dates, probably for April, and see where Shine is. Is there any, I mean, not that you're obligated to give me any insight, but can you offer any insight into what happened?
I'm sorry. I represent Pittsburgh. I apologize. I
Okay.
misrepresented. I'm here. I was just appearing to make sure
You're
everything
in
was okay.
Shine. Okay.
Yes,
So
I
you
apologize.
also
I
don't
apologize.
know what happened either.
No, I don't. No.
Okay. So maybe someday somebody will enlighten us. But in any event, Mr. Jarvis, this matter is not going to go forward. As I said, I don't intend to necessarily take the gas off, in the sense that the case is ripe for being fully adjudicated, to make it to a trial for that to occur. What I am going to do is respectfully take a moment and let Shine determine if they want to or are able to secure counsel that will pick up the ball and run with it. Now, full disclosure, if they show up with counsel who is really ready to get into it, am I probably going to give them a minute to catch a breath? Probably. But it is not my intention to needlessly delay the case if it appears that Shine is not in a position to proceed with it. So
Understood. Thank you, Your Honor.
thank you. Have a good day.
You too.
Okay, next up is Harris Community Association versus Volga Yurkina. Who do I have on behalf of Harris Commons?
Good morning, Your Honor. Harrison Woodworth here for Harris Commons.
Hi, Mr. Woodworth. And then who do I have here on behalf of Volga Yurkina?
Good morning, Your Honor. Charles Harbin on behalf of Ms. Yurkina.
Okay.
And Your Honor, Chad Brock, also on behalf of Harris Commons.
Thank you. Hi, Mr. Brock. There is I'm not exactly sure what got filed into the system that made this happen, but Mr. Brock, you appear on every one of my calendars as if you are counsel for the defendant. And so I don't know why that happened, but it's a thing that confuses me every time this case comes up. So a couple things that I wanted to note. This is on the calendar for a pretrial conference in advance of my civil trial week, which is March the 23rd. And I noted that there were there's a conflict that was filed, I think by you, Mr. Brock, but maybe I'm wrong. Maybe it was Mr. Harbin.
That was
Mr.
me,
Woodworth.
Mr. Woodworth.
Okay.
Yeah.
Sorry, Mr. Woodworth.
No problem.
And then there was, I think plaintiff's counsel also filed a leave for April the 6th, but since my trial calendar is March the 23rd, that shouldn't be an issue.
Right.
I also noted that a demand for jury trial was filed on February the 20th by, I believe, Ms. Yurkina. Is that right, Mr. Harbin?
That's correct, Your Honor.
Okay. I haven't seen a pretrial order. Has one been submitted?
Yes.
Yes,
Okay.
Your Honor.
Okay, then I need to find it in my email. And I'm sure it's there. I just hadn't seen it. And so I noted when I reviewed the file last night that discovery ended in November, but there seems to be an awful lot of traffic in this case, with ongoing discovery, which is fine by agreement of the parties, but the scheduling order that was entered by the court had discovery ending in November, and I could have overlooked it because sometimes the dockets get real full and it's hard to find the amended scheduling order, but I don't think there was one. And also there was a mediation deadline by February 23rd. I'm curious if the parties mediated and if there was any hope that this case might resolve. Who's going to answer?
I'm happy to address those
Thank you,
issues,
Mr.
Your
Harbin.
Honor. And there was a discussion regarding mediation, but my client felt that the parties were so far apart that mediation would not be helpful or fruitful in the case.
Okay.
As to the discovery issues, originally, in the beginning of the case, I had served discovery upon Mr. Woodworth before Mr. Brock became involved in the case. And unfortunately, they did not timely respond.
Right, and there was a motion for summary judgment, which I
Yes.
denied because instead I granted Mr. Woodworth's motion to revoke deemed admissions. And then I guess you guys were off to the races of more traditional discovery at that point.
Well, Your Honor, I had already served interrogatories and a notice to produce documents, and more than 60 days went by after the court ruled on the motion for summary judgment. There was no response, so I sent a Rule 6.4 letter, and eventually there was a response, but the response did not sufficiently answer the interrogatories, in my opinion, nor were all of the requested documents produced. And so after the Rule 6.4 letter, I filed a motion to compel. And your staff attorney made me aware of a requirement that and I have it here highlighted in yellow. No party may file a motion to compel until the moving party has first discussed the matter with the court staff attorney. And I did that, Your Honor. I discussed it with Mr. Freehoff, and I can report that Mr. Brock, Mr. Woodworth, and myself had a very lengthy telephone conference. And I believe that the discovery dispute will be resolved by and between the three attorneys. Mr. Woodworth has agreed to provide me revised responses to the interrogatories and additional documents. Nevertheless, I had asked for a time that we might have a conference with the court so that we could address these issues if necessary. And I am hopeful that we will be able to resolve it ourselves, and I think that we will be able to do that. But I would ask that that we be given a date so that we could have a conference with the court if necessary.
Thank you, Mr. Harbin. Any response, Mr. Brock, Mr. Woodworth?
That all pretty much sums it up. Yeah, we were hoping to smooth over any issues, but I think the idea was get on your calendar now, so no 2 weeks from now, we're not asking you to put us on a calendar or, give us a conference time.
Okay, so I understand that this is a homeowners association case and that they largely often do not proceed this far procedurally. I understand there were some hiccups at the beginning associated with missing some discovery that resulted in a summary judgment motion, and then I had to rule on those issues. But it also seems that the parties have largely ignored the court's scheduling order and the court's standing case management order that is attached by link to every email that anyone has ever exchanged with Mitchell Freehoff, who is my staff attorney. And so while absolutely everything that Mr. Harbin just said is eminently reasonable in terms of, yes, the proper method for me, as far as I'm concerned, to resolve a discovery dispute is to call the court and tell Mr. Freehoff, or email the court and tell Mr. Freehoff, we have a dispute. We need the judge's assistance, which is what y'all are saying. It's just that y'all are saying it on the day set for your pretrial conference. And this matter is set for trial May the 23rd. And the case that was supposed to be in front of you just disappeared because the lawyer withdrew. And so what I think you're really saying, also, that's why I started by noting that you guys seem to be engaged in ongoing discovery, is that I'm happy to host a discovery conference with you, which is, again, I'm happy to do those and give everyone guidance of what the court thinks is discoverable and not discoverable, broad strokes. But what y'all really need to do is ask me to continue from the trial calendar and give you an amended scheduling order, because it doesn't appear that you are in any measure ready for trial. Separately, the little bit I know about this case seems like an awful lot of litigation over $2,800. I mean, what I understand, I get I'm shortening it and it's a lot more complicated than that. But I mean, what I understand is this started as an assessment case against Ms. Yerkina for, I don't know if it was for regular assessments that were unpaid, but also for assessments associated with the replacement of a roof. But Ms. Yerkina's position is that she already replaced her portion or her roof or whatever. And then allegedly the homeowners association comes over and replaces the roof that she just spent $2,800 replacing. And that feels to me like something the parties ought to be able to work out instead of all of the litigation that has occurred in this case since it started in February of 2025. Having said all of that, I do want to be clear about one thing. I did ask about mediation. I don't want to imply that you have violated any order in that regard. I don't require mediation. I do give you a deadline by which I want you to conduct mediation if you're going to conduct it. So you haven't, it's not as if you were required to mediate and you did not. But you were required to comply with the scheduling order and then ask me for an extension if you weren't going to be able to conduct discovery and then be ready for trial. And I don't know if it's because these kinds of cases don't frequently go to trial, but it is a little surprising to me that no one on this call seems to understand that this is a pretrial conference, although I do appreciate your pretrial order, and that when I say you're on the March 23rd trial calendar, which is what I put in the pretrial or the scheduling order 6+ months ago, that I meant it, right? So you might need to ask for a continuance. Otherwise, you're going to trial on March the 23rd. So what are we doing, gentlemen?
Your Honor, if the court would grant a continuance until the next trial calendar, I think that would give the parties plenty of time to resolve the discovery dispute. And perhaps, I'm not saying that we will be able to settle the case, but we could at least have some further discussions.
Okay. Mr. Brock, Mr. Woodworth, what are your thoughts?
Oh, sorry, go ahead, Mr. Brock.
I agree. I think a continuance makes sense.
Well, I'm
And
not happy about it, but practically speaking, I don't know that there's any way that you guys would reasonably be ready for a trial. And now Mr. Harbin is demanding a jury trial. And while these issues may be straightforward, if you're not prepared, you're going to drive a jury insane. If you're not prepared and actually know what the facts are of your case in terms of presenting it, if it gets that far. Okay. So it sounds from both the plaintiff and the defendant that you guys would like to try again in April. What I think I'm gonna do is, how much do we think we need to work through in terms of the broad strokes of discovery? Are we talking 100 interrogatories, or are we talking, a 30-minute conversation about general topics associated with the discovery requests? Mr. Harbin?
Your Honor, I think it's pretty straightforward what the issues are, and I believe that 30 minutes would be adequate to address whatever those issues are if we cannot resolve it ourselves. And again, Mr. Woodworth, Mr. Brock, and myself have had a very meaningful conference call, and I anticipate that we will be able to resolve it ourselves. But just in case, Your Honor, I want to try to make sure I'm in compliance with the court's scheduling order or amended scheduling order and not have to come back at a later time and address this issue again.
Okay. So what I think I'm going to do is I'm going to reset this matter to April. I am going to have Mr. Freehoff reach out with dates for you, probably that civil trial week, that y'all can have a discovery conference with me if you think you need one to resolve disputes about the scope and scale of discovery and particular issues that might have arisen. Beyond that, you would be looking at pretrial in April. Again, I can tell you that it would be, let's see, it would actually, I say April, but your pretrial conference would actually be April the 2nd. It's the week of the 30th of March. And your trial would be the week of, I think, the 20th of April. And so the other thing I will tell you is, although I am happy to try and provide some guidance regarding like I said, the scope and scale of discovery that's already outstanding, part of the deal is, y'all are free to engage in discovery outside of the scheduling order, but I don't generally get into the business of compelling discovery that somebody won't voluntarily provide when you're wildly outside of the discovery scheduling period. So, take it for what it's worth. It feels like the discovery that y'all have issues with were served within the applicable discovery period. And so I'll hear from you on that. But anyway, anything else that y'all need from me regarding this matter, other than I will send out a new notice and we will see you guys for an actual discovery conference, if one is necessary, probably the week of March 23rd, and then a pretrial conference in advance of trial, probably on April the 2nd. Any other questions for me from the plaintiff, Mr. Woodworth or Mr. Brock?
No, Your Honor.
No, Your Honor. Thank you.
From the defense, Mr. Harbin?
No, Your Honor.
Okay. Thank you all. Have a good day.
Thank you. You as well.
Thank you.
Thank you.
Okay. Next matter is Mr. Batia and Mr. Karana. And if I apologize if I mispronounce anyone's name, I'm trying to do my best. Do I have any counsel here on behalf of Mr. Batia or Mr. Karana? I know originally each of you were representing yourselves. I saw that each of you had gone to a mediation. The mediator indicated that although you did not resolve the case at mediation, that y'all had made good progress, and he was hopeful that perhaps y'all might get to an agreement. So first question, starting with Mr. Batia, is are you still representing yourself, sir?
Yes, ma'am.
Okay. And Mr. Karana, are you also still representing yourself? So Mr. Karana, you're muted.
He's muted.
I always say it wouldn't be a Zoom hearing if I didn't have to say that at least one time. Mr. Karana, are you still representing yourself, sir?
Yes, Your Honor.
Okay. And I don't want to know what you discussed in your mediation because that's confidential. But do you feel like you have made progress in terms of the possibility of working it out? Or do you feel like you still need to be on the court's calendar to try the case? What are your thoughts, Mr. Batia?
A calendar on trial.
Okay. And Mr. Karana?
Your Honor, I still believe that we can resolve that issue unless he's stuck on some particular issue that we can go ahead and do what we need to be done.
Okay. So this would be a non-jury trial and it would be in front of me. I would be the one that would handle the case. What I think might be helpful in this case, I mean, it is technically my civil trial week is March the 23rd. Would you be prepared to try that case that week, which is 3 weeks from now, 2 weeks from now? Mr.
Yes.
Batia
Yes, Your Honor.
and Mr. Karana.
Yes, Your Honor, I have no problem with that.
Okay. So even though this is a non-jury trial, I usually have lawyers prepare something called a pretrial order. And what that is a form document that's available on if you Google Fulton County and Judge Krause, it's on the website. And what it does is it makes the party each party think about what are the issues that they want tried, what are the documents they're going to use to prove it, what witnesses are they going to call to prove their case. And I find that it is very helpful for lawyers to sort of crystallize down what it is they're planning to try and prove at trial. And I have found that even though some of it is a little bit legalese, that it is actually helpful for non-lawyers because it helps you think about those same things. And then it helps me understand the case from each of your perspectives in terms of what Mr. Batia claims and what Mr. Karana is planning to defend. And so what I wonder is if I could impose upon you, even though it's a non-jury trial, if I could ask that the parties complete that. So the way it works is, and Mr. Freehoff would provide it to you, it's a Microsoft Word document, and it's just asks, I think it's got like 19 or 20 things, and it asks you, what is your narrative of what happened here, right? Who are the witnesses you think are necessary for the case? What documents are you going to, and you don't have to list out each single document, but like referencing the types of documents, like if there's financial documents you're going to offer, or if there are business documents you're going to offer, that kind of thing. I can't help you guys fill out those forms because I'm not supposed to give you legal advice, and I'm supposed to treat you as if you were represented by counsel, or at least not treat you any different than I would an attorney. What I would like to do for now is, if I can, instruct the parties to complete that pretrial order, and then perhaps send it to me by the end of next week, which I believe is the 13th of March. Is that something that if Mr. Freehoff sends you that form, Mr. Batia, that you would be able to, that you would be okay with filling out, and that you could, send back to me by this coming Friday so we can figure out, it makes you do things like, how long is it going to take to try the case, if you think, and that sort of thing. Do you think that's something you could do, Mr. Batia?
Yes, Your Honor.
Okay, Mr. Karana?
I can do that, Your Honor.
Okay, excellent. So I know that Mr. Freehoff has email addresses for the two of you and has been in email communication with you. I'm going to ask that he forward you, when we get off of this call, the pretrial order form. Again, some of it you might not understand. Just do your best. I'm not looking for perfect here, but I do think it will be very helpful to me to have a better understanding of what it is that Mr. Batia is hoping to gain or prove or recover in this case. And Mr. Karana, what it is that is your defense to that. And I understand this is not a perfect document, but it will be very helpful to me. And then once I have that document, then I will be back in touch with you to let you know if I want you to come in on the 23rd of March, or if it will be on a different day that week. to try the case. But I need to know a little bit more about your case and about how long I think it will take for me to work with you to get through the information before I know what day I'm going to call it in, because I have to know how long it's going to take. Does that make sense, Mr. Batia?
Yes, Your Honor.
Mr. Karana?
Yes, Your Honor, but I have a question. Would that be a meeting, personal meeting, or would that be on Zoom? Because I'm unable to move around. I'm disabled and have a problem in coming to the court and so forth.
So right now, I'm just talking about y'all sending me
Right.
the pretrial order, which is just a matter of emailing it to Mr. Freehoff,
Right.
filing it with the court. For the trial, one of the things we would talk about is whether or not we could conduct the trial by Zoom. If the parties are okay with doing it by Zoom, we can. But there are some technical limitations with doing that in terms of if there are documents you want me to look at, if there are witnesses you need to call. We just need to walk through what the logistics of that look like and whether or not Mr. Batia has any objection to it, because the parties have to consent to trying the case by Zoom, which, as I said, I'm perfectly comfortable doing, have done it before, but it is something to which the parties must consent. Okay?
Yes, Your Honor.
Okay. Any other questions for me about what I'm asking you to do, deadlines, and what you can expect next, Mr. Batia?
No, I'm fine with it.
Okay. Mr.
Thank you.
Karana?
No problem. I'm
Okay.
fine.
Okay. Thank you, sir. So Mr. Freehoff is going to mail you the pretrial order form, and then I will look for that pretrial order form to come back to us with your inserts no later than next Friday, which is March the 13th. And then we'll go from there. Okay.
Yes.
All right.
Excellent. Thank you, gentlemen. And I will look forward to your pretrial order.
Sure. Thank you, Your
Thank you.
Honor. You have a good
Thank
day.
you, Your Honor.
Thank you.
Have a pleasant day.
Bye-bye.
Thank
Bye-bye.
you, Mr. Kurana. Have a good day.
Bye-bye.
Okay. Ms. Story, Mr. Gaba, to what do I owe the pleasure? Because according to the calendar I'm looking at, what I have coming up next is not until 11 o'clock. So tell me what you are on for, Ms. Story.
Your Honor, we spoke with Mr. Freehoff by email last night regarding the consent order, and we just wanted to make sure you had what you needed. For the
Yes,
consent
I'm
order.
sorry. Yeah, I apologize. Yes.
No, you're
So
fine.
this is the
DOT
yes.
condemnation matter.
So here's what's going on, just for your benefit. So first of all, the substance of what you've submitted is perfectly fine. I have no issue with it whatsoever. Happy to get it off my docket. Glad to not have to try the case. All those things are good. The issue is this. The clerk of our court has recently brought to our attention that the orders that are being submitted are, in her opinion, her concern that she brought to us and asked us to consider is they're really contingent orders, right? Because although probably that is not the case here, y'all probably have the entire case fully resolved and are ready, standing by to file a Rule 23 saying, hey, judge, disperse the funds right now. But we all know in these kinds of cases, there's always those one or two cases where the two people left in the case can't figure out and resolve who's going to get what percentage of the $260,000 that's getting paid in. And the simple fact is, when that happens, the clerk is not supposed to pay those monies out without a proper Rule 23. And what the clerk is saying is that the order that you submitted to me, it has just a paragraph that's functionally contingent. It says, hey, clerk, when you get a Rule 23 certificate, then you can pay out the money. And what she's saying is that leaves her with a closed case holding on to money. And then a Rule 23 gets presented with no filter as to whether it fully adjudicates or is an appropriate Rule 23. And so what she's asked us to do, and I'd reached out to some of my friends like Ivy Cadle and some others that I know work in this space, and said, hey, look, you might be getting a little pushback from us, because really what we're looking for is a 2-order process instead, right? So send me your consent order that says the parties have agreed to everything. The only real change I need is that instead of when a Rule 23 is submitted, the clerk can pay out, it'll need to say the parties will submit a Rule 23 and the court will then direct the payout. That's really the main difference here.
Let me ask this. Can
Yes.
I maybe we change it to attach as Exhibit B is Council's Rule 23.
Absolutely. If there is
Okay.
already a Rule 23, then that solves your problem.
Yeah, okay. Nick, I assume you don't have an issue with me attaching a Rule 23 to the
I have
order.
no
Is that okay?
issues. I have
Yeah, I
no
mean,
issues.
we just recently have run into an issue. There are, I think, 4 pending right now where they are 4 years old, right? The DOT has already done all its stuff, whether it was a city DOT or, or the state DOT or whatever. And there's, this clerk's still holding on to north of $1 million because 3 parties can't get resolved on the, $1,000 that one party is entitled to and the other party is entitled to the rest of it. So
No, that's a fair concern, and I'm actually glad we got to talk about it.
Yes.
We will start moving forward, making that adjustment just on our
Right,
end, so that
and
we
my
don't
feeling
have to.
is if it is really a situation where the case is fully adjudicated, right, then just do it exactly like you're suggesting is attached as a proper Rule 23. And then I will be, hey, clerk, disperse the
done.
funds.
Okay.
Yeah.
If it's not that situation, then I still feel like I think it sort of morphs into an interpleader at that point where the DOT is like, hey, look, we did everything in our power. All the powers that be agree this is fair market value. We're paying it in. Those guys can figure it out. And then I'll wait for a Rule 23 from those guys.
Yeah, no, that's fair. And I'm trying to think why we do it this way, other than like we usually just don't put it as part of the final order, and then we sometimes, I guess what we have started doing, we would put the text of a Rule 23 in the order, and then we got
Mhm.
pushback on that from DOT being like, we aren't supposed to be part of that.
Yes.
No offense,
Yes.
Nick.
We've done it both ways where
Yeah.
we've attached or had the condemnees attach a fully executed Rule 23 or say upon submission of a Rule 23 certificate substantially similar, then the clerk shall submit. So
Right. And that's
what is
really
the-
what
we'll turn that
what
phrase.
what the clerk is uncomfortable with is the contingent language that says that has the court saying when the parties get around to submitting a Rule 23, clerk, pay the money. What the clerk wants to be very clear about is that she's not paying any money out until she gets an order from me that says I have received a proper Rule 23 and you are authorized to disperse the funds, because that's what the rule says. We just all have been sort of floating around it because nobody really cares, because most of the time all the T's are crossed and all the I's are dotted and everything is fine.
That's fair. We're going to fix the numbering issue, and then we are also going to resubmit the order with a new exhibit.
Okay, and spread the word about
I
that,
will.
because like I said, I did speak to Ivy briefly, and at one point we were like, do we need like, I mean, as a side note, there was some discussion of the fact that, the good lawyers, right? Usually what we run into is we get mess stuff that isn't by the good lawyers. I'm like, no, this is the issue is we want to spread the word with the good lawyers who know what they're doing to like build out their form in a way that is more favorable to what we're trying to accomplish. And so
100%.
spread the word amongst your colleagues that we would very much like to sort of uncouple that Rule 23 language that makes it contingent and instead either attach it or indicate that the case is fully adjudicated from the DOT's perspective and that the court will later, upon receipt of a Rule 23, will enter a separate order on disbursement.
Absolutely. Makes sense.
Makes sense.
Excellent. Thank you so
Glad
much.
we had the chat. Yeah. Thank you
appreciate
very
it.
much.
Thanks for your patience while I got through the other stuff too. I
It
appreciate
was
it.
Yes,
entertaining.
ma'am. Yeah, that it was.
Yeah.
Enjoy your trial week.
Oh yeah. Have a good day.
Thank you.
Yes, ma'am. You too.
Hi, Miss Jones. You're muted, Miss Jones.
Sorry, I had to make you say it twice.
No worries.
I just wanted to confirm that Sable Point was not on for today. I know we had an amended scheduling order sent to us, but it all happened kind of last minute. So I was just
Yes.
making sure.
Basically same thing as you sort of heard me lecturing those other guys. Yeah, it was, we were aware that y'all needed some additional time. And I think once we entered that amended scheduling order, the amended notice might have crossed in the mail. But yes, I appreciate your being cautious about it and not showing up. But as far as I'm aware, Mr. Freehoff can confirm it was moved and there's no prejudice to anybody at this point, right?
That is all correct.
Excellent.
Thank you so much. Then I
Thank
will
you,
go
Miss
on about my
Jones.
day.
Have a good day.
You too.
morning.
Good morning, Your Honor.
Good morning, Your Honor. Let me start this. There we are.
Good
morning, Judge.
Good morning, sir. Mr. Douglas, I appreciate you multitasking, but could you turn off your video until you get stationary? Because otherwise we're going to get motion sick.
Okay, I am stationary.
Thank you, sir. Okay, so this matter is. I'm sorry. Somebody's got something interfering. Mr. Sanders, can you mute, please, to make sure that audio is not, thank you. Okay, so the reason this matter is on the calendar is this is an oddly postured case where the plaintiff, Mr. Sanders, filed an action against Errol Allen and some others, and ultimately ended up with a default judgment. And then a writ of FIFE was issued, and then it seems that there's some indication in the file that there was some either effort at garnishment or successful garnishment. I don't know because it's not really in my case. And then what happened is I received from Mr. Douglas on behalf of Mr. Allen a request to set aside the default judgment based on an argued lack of service. And it was a properly supported motion in the sense that it was accompanied by an affidavit that attempted to provide the court with some evidence or justification or explanation for why allegedly the service was invalid. And Mr. Sanders did not file a response. After that, the court, as is its practice, sent an email saying, I'm inclined to grant the motion, send me a proposed order. And then Mr. Robinson responded and said, wait, I'd like to respond. I had a leave of absence. I just, overlooked it. Can I please have an opportunity to respond? And he then did file a response. And I'll say there's two things going on. Number one, once Mr. Robinson appeared, I had not yet executed the order that was presented to me by Mr. Douglas at my request. Two reasons I've not done so. One of them is that Mr. Robinson appeared and asked, could I be heard on this? And two is because Mr. Douglas, the order that was submitted, I think was a little bit of a bridge too far. It would be one thing for me to set aside the default judgment, but I don't have any authority to set aside any garnishments. They didn't occur in my case. They, I think, didn't even occur in my county. And the order that was presented to me actually wanted me to order that any garnishments were null and that they had to be returned. And that was way farther than anything that I might do. At best, if the court were inclined to enter an order setting aside the default judgment, all that would happen is everything would sort of maintain stasis until we actually litigated the merits of this matter. And so that's where we are. I have read the briefing, and as I understand it, Mr. Douglas, it is your client's motion. And it is, and just to sort of procedurally center it in terms of what the standard is for overturning. I mean, there's an affidavit that says service was made, and Mr. Allen did not respond. And it appears what happened is Mr. Allen didn't respond until someone executed on that judgment. And then all of a sudden was like, wait a minute. And there, I think, are some heightened evidentiary burdens that flow from trying to challenge what is otherwise regular course of business affidavit asserting proper service. And so that's where I think the case is. From there, Mr. Douglas, I'm going to hand it to you and tell me what you want to tell me regarding this matter and what we do next.
Yeah, so thank you, Judge, for the opportunity. And just for efficiency, I don't want to take up these, but we've got a lot of parties on this call. Your Honor, I'm sure has a ton of cases and is really busy. I am also physically in court in the courthouse on 6 for a hearing as well.
Well, I appreciate you stepping out to do this one. Thank you.
Yeah, it hasn't concluded yet, but the judge there is aware.
So for that reason, I'll just sort of jump straight to what we think happened here. And my client is prepared to testify to this effect. But my client during that time, had a tenant that lived in the basement of his home. The description that the sheriff's deputy gave in the affidavit of service appears to match that person, not my client. My client has never been bearded. The sheriff specifically, or I'm
Well,
sorry, private
hang on,
process.
Mr. Douglas, let me save you some time. I've read the affidavit. I understand what the issue was, and I understand some of the information I was provided by Mr. Allen through his affidavit about whatever. But at the end of the day, last time I checked, leaving service, a summons and complaint with a responsible adult who resides in the same place as the defendant is known to reside is valid service. I mean, it's unfortunate if that person accepted service and then didn't give it to Mr. Allen, but wouldn't that still be valid service?
No, because again, they have two separate houses, so to speak. You know, he doesn't live with my client, and therefore, and that's part of the reason why my client never got notice. That gentleman is a truck driver, and this is just speculation, because what is clear is that my client was not served, and that's ultimately the bottom line. I've read counsel's response. I appreciate it. It does not, though, establish that service was confirmed. There's a lot of speculation on their side about, various things, but again, and about the merits of the case, but that's not what's at issue before the court today.
Right, but isn't the burden, as I mentioned, the heightened standard? I mean, don't you have to demonstrate by not just a preponderance, but clear and convincing evidence that service was not properly made at all, or whatever was made was insufficient?
Well, I don't know that it rises to that level. I mean, the case law that we state in the brief says that essentially all that has to be done, and one of the cases actually says that this is all that was done, was that there's an affidavit that says that he wasn't served. But in addition, over and above that, we've established that the description does not fit him, and that he would have been away from the home at that time. So we've gone above and beyond what case law requires.
Right, which is why I originally
rebut
indicated
service.
an inclination to grant the motion, albeit without the benefit of a response from Mr. Robinson. And with that, Mr. Douglas, I'm going to let you have just a last quick word, and then I'm going to
Yeah,
Robinson.
I'll just add that counsel and his client aren't, the plaintiff in this case, aren't prejudiced by Your Honor granting the motion, because as Your Honor stated, all that does is just resets us so that we can argue the merits of the case, which is what they've clearly prepared to do, because they did so in their response to the motion to set aside. So it doesn't in any way hurt them. On the other hand, however, if Your Honor, denies the motion, it does in fact hurt and prejudice my client, because he didn't get the opportunity that he should have gotten if he had been served properly to defend himself.
Okay, understood. Thank you, Mr. Douglas. Mr. Robinson?
Your Honor, I'll principally stand on my brief, but I do want to point out a couple of things for the court. Number one, the court is exactly right in terms of either this is personal service or it is notorious service, because this was left with an adult that lives in the same home. Now, I noticed counsel said something about these are separate homes and so forth. I don't know of any case law that separates the basement from the first floor from the second floor, but at the end of the day, he was served at his residence. If counsel is conceding that his tenant received the service and he's a truck driver, well, it'd be great if we have that tenant here today, or we have something from this alleged tenant telling us that I received service and I just didn't give it to him. And Your Honor, I think that's where it plays into the clear and convincing standard, because it is his residence. And in fact, in their pleadings to the court, they never argue that it's not his residence. So I think it's rather strange that we hear this two houses comment from counsel today, because that's not something that appears in their pleadings. Number two, by admitting that it was served on a tenant within the property that lived in the basement. Your Honor, there is no, when the sheriff or a private process server makes service and the person appears at the door and they respond to the calling of the defendant's name, they are entirely within reason to rely upon, you said that you are Errol Allen. You are Errol Allen. Now, if the tenant was saying I'm Errol Allen because he lives here, or this is the property and he's here at home, I don't want to speculate, Your Honor. But under either analysis, this is service. This is service, and based on what's been presented here, counsel wants to argue that we have met the statutory minimum to have a default judgment set aside. I agree that there are statutory minimums, Your Honor. However, the evidentiary requirement is clear and convincing. And here, it was his home. There was an adult served at his home. There is no one here to say that they were served and didn't give it to Mr. Allen. And Mr. Allen has not provided us with any evidence to dispute the affidavit of service that was filed, by the way, several years ago. So, Your Honor, I'll stand on my pleadings, number one. Number two, I believe this is notorious service. And number three, this argument that some other house was served, there is no evidence of that in the record, Your Honor.
Okay.
Judge, may I just briefly respond?
Yes, sure. I mean, it's your motion, so I'm going to give you the last word anyway, but I would like to ask a quick question. While Mr. Robinson was talking, it reminded me, I did receive some sort of ex parte request for something from Mr. Sanders. I want to make sure that Mr. Robinson is still authorized to proceed, because I was a little unclear about what I had received from Mr. Sanders. I'd rather not hear from him directly if he is still represented by you, Mr. Robinson, but I do want to put a pin in that issue.
Okay. Would you like me to address it now, Your Honor, or
Yes,
come back to
please.
it?
Just
Okay.
Quickly, if you can now.
Certainly. So we had been assisting Mr. Sanders in post-judgment collection issues.
Yes, sir.
And Mr. Sanders has said that he no longer wants us to assist him in post-judgment collection issues. So, for example, it actually wasn't a garnishment. It was actually a encumbrance that was filed on properties that the trust owns.
I see.
And we had been trying to collect that. So Mr. Sanders has asked us to no longer proceed on that.
Okay.
I shared with Mr. Sanders that obviously there's attorney's fees involved in this particular judgment, that I would go ahead and respond to this and defend the judgment. However, post-judgment collection will be Mr. Sanders.
Okay. And that is something for y'all to work out later, Mr. Sanders. I just wanted to confirm that Mr. Robinson still represents you today for purposes of this hearing. Is that correct, sir?
That is correct. I think what you saw was, I mean, obviously I'm a novice at this. I've never been in this situation before. So I did a continuation, and I sent it to the staff attorney so that I could, because I am going to retain counsel within the next couple of days. So I didn't want to come into this situation. I didn't know Attorney Robinson was going to be here. So all I had was the information that he had provided me.
Yes.
I obviously don't know how to present that information to you, Your Honor. Okay. So I was kind of nervous as to showing up by myself.
No, I understand, and I don't want to hear any more than necessary or know any more than necessary about your relationship with Mr. Robinson. I just wanted
this is fine today.
Right, for my own benefit, to make sure that what Mr. Robinson is authorized to represent you for this proceeding today, and then y'all can take whatever action later. Okay.
Yes,
Thank you, Mr. Sanders. Thank you, Mr. Robinson, for clarifying that. Both of you now, Mr. Douglas, it is your motion, so I am going to give you the last word, sir.
Yeah, I'll just say that council can't have it both ways, right? Like, you can't rely on the theory that I put forward this morning to establish notorious service and then say that there isn't enough or that this information hasn't been presented in the pleadings. And I just want to make clear also that it is just a theory. Like we don't know what happened. And my client can testify to that if the court deems it appropriate, that it's just a theory that the description seems more like his former tenant than it does, then clearly it does him. But that's all we don't know that he was the one who was served. And I'm not, counsel made reference several times to an admission that the tenant was served. That's not, in fact, I just want to be clear to the
No.
court. I am not admitting on my
Don't
client's
worry,
behalf.
Mr. Douglas. I'm not gonna hold you to
Okay.
any sort of admission in judicio or otherwise, right?
Okay, yeah, I mean, what I am admitting to is that my client was not served. And that's what's required. That's what the statute requires, is that he be served personally, and he wasn't. And
Right.
we don't know if an adult in his home was served. And that's why the burden shifts then to counsel to prove that he was, and that has not been done. And that's why Your Honor should grant the motion to set aside.
Understood. So I am the one who asked the question about notorious service, and ultimately I'm not going to tell you what my ruling is today. I'm going to take it under advisement and issue an order that I'm not going to ask for anybody to draft. I'll just draft it all by myself. But basically what I mean, I will tell you that what I'm going to be looking at, and the reason I asked about notorious service is that while there are different ways to serve someone, my understanding is it doesn't matter how you do it as long as it is legally allowable and sufficient. And so what I'm going to be looking at is two things. One, whether the actual service that was attested to was legally sufficient if it occurred, right? If you believe that it occurred in any form or any manner as described in that affidavit, is it legally sufficient? And two, if it was legally sufficient, has Mr. Allen satisfied the clear and convincing standard to demonstrate to me that the legally sufficient service that occurred allegedly in that, as attested to in the affidavit of service, is somehow that he has refuted that it actually occurred. And so those are the two things I'm going to look at, and I'll get you an order, and I'm going to try and get you an order as quickly as I can, so that everybody knows what they're doing. And today is Thursday. I have some free time. It's going to be a very succinct order, but I'm going to try to get something to you tomorrow. I did have one question to Mr. Douglas's point. Or maybe it's Mr. Robinson's point, that it wasn't a garnishment, that it was some sort of attachment. What happens if the court opens the default, sets aside the default?
I can respond to that.
Yes, sir.
We would send a copy of the court's order to the court that granted whatever that post-judgment collection activity is, whether it's a garnishment, whether it's a lien, whether anything, and that court would then stay the post-judgment collection action pending the outcome of the case on the merits.
Okay.
We do a lot of these, and so I'm very familiar with the process.
Okay, understood. Thank you all, Mr. Douglas. I'll let you get back to your hearing, and Mr. Robinson, gentlemen, Mr. Allen, Mr. Sanders, I will provide you with an order as soon as I can, and then we'll go from there. Okay.
Thank you,
Thank
Judge.
you all.
Good to
Have a
see
good
you.
day.
You too.
Good to see you
Thank
too,
you,
Mr.
Ron.
Douglas.
Okay.
Ms. Williams, this is Deidre Nash, reporter. Can you check your chat? I sent you a question in regards to the case.
Yes, I'll do that.
Thank you so much.
Hi, Giovanna. Mhm.
Good afternoon.
Good afternoon.
Hi. good-
Hi, Madam Court Reporter. Are you ready?
Yes, ma'am, I am.
Okay. This is going to be a hearing in the matter of Stalin DeGrilla versus the Georgia Board of Nursing, case number 25 CB 008-385. We're here for oral argument on Mr. DeGrilla's petition for review of a decision by the Board of Nursing declining to provide or grant a rule waiver to allow his licensure in the state of Georgia. As a registered nurse, I believe. And anything of that I just said was incorrect, please correct me when it is your turn to speak. I would first let me ask for announcements of counsel for the record, starting with counsel for Mr. DeGrilla.
Hello, Judge Krause. It's nice to meet you. My name is Hannah Williams. I am representing the petitioner in this case, Stalin Ronnie DeGrilla.
Okay, thank you, Ms. Williams. And who do I have here on behalf of the respondent?
Good morning, Judge Krause. This is Giovanna Franchi Souza, and I'm representing the Georgia Board of Nursing.
Okay, hello, Ms. Souza. And who else do I have on here?
Good afternoon, Your Honor. My name is Jeff Bazinet. I am one of the attorneys who is assisting the petitioner, Mr. DeGrilla.
Okay, thank you, sir. And so I assume for purposes of today that I will hear from Ms. Williams and Ms. Souza. Is that correct?
Yeah, Judge Krause, yes, I will be doing most of the argument, but there may be times where Attorney Jeff Bazinet chimes in on some things.
Okay, just don't unfairly gang up on Ms. Souza. I'm sure she can handle it, but we're not going to do that. But other than that, I'm sure it'll be fine. With that, I will throw it over to you, Ms. Williams. Before I hand it over to you fully, I will say I have had a chance to review the record, have reviewed the briefing. Admittedly, I did not review the reply and the surreply, and that's because my standing order says you can't file a reply without asking if you can file a reply, and nobody asked, so I didn't read them. That doesn't mean you can't make those arguments to me now in this oral argument. I'm just telling you I haven't read that part. And beyond that, I do have I try to develop a general understanding of these cases and then let y'all tell me what the ins and outs are. I framed it a little bit at the beginning, so I feel like I have some understanding, and hopefully that will help you focus more on the legal arguments and less on that you have to educate the judge about what the underlying facts are, because I feel like I understand them. But if anything I've said is incorrect, or if you feel like you need to expand on those, it's your show, it's your motion, your petition, so I'm happy to let you do that. Go ahead, Ms. Williams.
Of course. As an initial matter, thank you for being here today, everyone, and also thank you for granting Mr. DeGrillo the opportunity to have oral argument. I do want to address the reply briefs. So the scheduling order that we asked the court to enter had a deadline for replies and replies.
Okay.
Our understanding that the replies.
That's entirely on me. Then that means that as part of entering that order, I gave you permission to file them. So I'll make sure they get read, and I apologize if I cast any aspersions on anyone.
Okay. All right. Again, thank you everyone today for being here. My name is Hannah Williams. I'm here to represent Mr. Stalen Ronnie DeGrillo in his petition for judicial review of the Board of Nursing's denial of his petition for rule waiver. Mr. DeGrillo is from Trinidad. He came here in 2018 with dreams of becoming a nurse, and he did just that. He became a nurse. He graduated from Carleen University. He first attended Concord Health Institute and obtained all of his core nursing courses at Concord. All of those nursing courses were done at a school that is nationally accredited, which Concord is, and those nursing courses were transferred over to Carleen. He completed 2 more courses at Carleen and obtained his nursing degree from Carleen. After that, he applied for licensure in the state of Florida, as an RN, and he was granted licensure as an RN in the state of Florida. He was granted that license in 2023. So today we are here because Mr. DeGrillo has applied for licensure as an RN twice in the state of Georgia, the first time in 2023, the second time in 2024, and both applications were denied. And the reason given for denial was that his school was not nationally accredited, and that requirement is in Rule 410-8-.01, subsection 6. So Mr. DeGrillo asked for a waiver of that rule as it applies to his school, and the board denied that waiver request in 2 different denial letters. There's a 2-step process that the law requires the court, Your Honor, to apply when deciding on a petition for judicial review. The first step is there any evidence to support the board's findings of fact? The second step is to determine, are the conclusions of law drawn from those findings of fact legally sound? In this case, the board committed a fatal error when they released his 2 denial letters. The first denial letter was released on May 20th, 2025, and that denial letter violates OCGA 50-13-9.1 subsection E, which requires the denial letter to have a statement of facts and the reasons upon which the board based its denial. When that denial letter was released on May 20th, my office, myself, drafted a letter and email to the board on May 22nd, reminding them of their statutory obligation to provide a denial letter that met the statutory requirements. The board responded that same day and released a second denial letter on May 22nd that also violated the statute. Both denial letters do not contain any statement of facts, do not contain any reasons upon which the board based its denial. That is an irreversible error, and the board had ample opportunity to fix it. Mr. DeGrillo was under no obligation to remind the board of their statutory obligation to release a denial letter that meets the requirements of the statute. But as a courtesy, we did that on May 22nd, and the board still did not release a denial letter that met the statutory requirements. So here we are. We filed for a petition for judicial review of the board's denial letters. And because of this irreversible error, the consequence of that for the board is that Your Honor is confined to the administrative record, confined to the reasons that the board gave for their denial that are in the record. When we filed for the petition for judicial review, we only had a conclusory statement from the board in both denial letters saying that the specific claims of his hardship did not provide sufficient justification to warrant a waiver of the rule. There was no fact finding. There was no conclusions of law based on a fact finding, like the statute requires. In their responsive documents and in their briefing, the board is attempting to introduce several extra records record arguments that are not in the record, nowhere in the record. And we are asking, Your Honor, to strike every single extra record reason that the board is going to give you for denying this petition. That is going to be a standing argument because you will hear several extra record reasons today, just as you read them in the briefs. The procedural flaw alone means that this court should find in favor of Mr. DeGrilla because there is no fact finding for the court to apply the any evidence test. There is no fact finding. Because there is no fact finding by the board and there is no evidence to support their decision in the record, the any evidence test cannot be applied.
Right, but Ms. Williams, wouldn't the remedy there, though, be simply to avoid the merits and remand the case back to the board to provide me with a legally sufficient decision? Because the issue, I wonder if the issue is not just, well, Mr. DeGrilla wins because the board didn't give any reasons, or the issue is the court can't meaningfully determine if there were any facts in front of the board. And if that's the reason it's a problem, then isn't the answer, hey, board, give me a better letter so I can actually conduct a meaningful review?
Fair question. My answer to that is no, that is not the remedy. And the reason why is because we filed this petition last summer. The board has had ample opportunity to file a motion to supplement the record with the reasons for their denial. They did not ask for that remedy. We are here at oral argument, and Mr. DeGrilla has borne the cost of attorney's fees and time to argue this case, and to simply remand it back to the agency to give them a second go when they didn't even ask you to would be extremely unfair to Mr. DeGrilla and would prejudice this case. We filed a motion to supplement, and Your Honor ruled on that motion to supplement with documents that we wanted in the record that we didn't put in the record, quite frankly. The board has never went through that exercise. Instead, they introduced these extra record reasons in their briefing without any permission from the court. So for them to hear Mr. DeGrilla's entire case in this setting and then be remanded back to having the benefit of hearing everything and then be able to draft an elaborate memo of all of the reasons would prejudice Mr. DeGrilla. And they did not even ask for that relief. So again, the procedural flaw alone should help Mr. DeGrilla to prevail in this matter. But to oblige the court, we will go through the extra record reasons, 2 of them that the board issued in their briefing. We will discuss those. However, we have a standing argument that those extra record reasons should be stricken, but we will entertain them for purposes of completion of this proceeding.
Understood and appreciated. Go ahead.
Number 1, the board's conclusory decision that his hardship, he failed to show hardship because the specific claims his petition did not provide sufficient justification, is arbitrary and capricious. Applying the any evidence test to that reason, there is no rational basis that the board gave for making that determination. According to Burke County versus Askin, you have to have a rational basis for making an agency decision. And if you don't, then that agency decision is considered arbitrary and capricious.
So you guys know a lot more about the way the nursing board makes its decisions and what might have been at play here. But as I understand it, very at its most basic, right? The Board of Nursing's job is to, just like the state bar's job, right, is to not let people become licensed to practice that particular specialty unless they are sufficiently qualified so as not to pose a danger to the people of the state of Georgia. And so I'm assuming that as a policy-making body, that's why a rule like 410, whatever exists, that says, you know, we're not going to let people get licensed who graduated from a school that was not accredited and or completed some or all of their pre-license coursework at an unaccredited agency. And so I guess one question I'm struggling with is when you say their decision doesn't have a rational basis, how is it not like sort of just plain that here's the policy, right? Which no one's challenging. I mean, it is the policy. And it's rationally related to the purpose of what the board does, and the board has applied that policy to exclude Mr. DeGrilla. Why is that not an immediate rational conjunction between those two things?
Great question. So the rule is not a policy that the board used to deny his application is Rule 410-8-0.06. That rule was intended for the board to use when they're approving in-state schools. Nursing schools that are in the state of Georgia who are applying for board approval. That is what that rule is intended for. It's not intended for out-of-state schools. So you may ask, how did we get to that rule being relevant to his application? So I'm going to skip forward a bit in my argument, since you asked that excellent question, and explain to you one of the extra record reasons that the board is giving for denying his petition is they're saying that they can't waive a statute, that the statute requires the school to be approved, so they can't waive his petition. That argument wasn't in the record. It was not in their denial letter, but let's address it. So what I will do is I will share my screen here. And on the screen, you will see 43-26-7. This is the statute that the board has said in their briefing prevents them from being able to approve Mr. DeGrilla's petition for rule waiver.
Mm-hmm.
It's an extra record argument, and it's legally flawed, and here's why. This statute says that an endorsement applicant has to submit an application. It's not in dispute that he did that. Secondly, he has to pass the NCLEX, not in dispute that he did that. And third, he has to graduate from an approved nursing education program. Here's the dispute. Code section 43-26-3 defines approved nursing education program. So the analysis doesn't stop there, but the board is asking the court to stop the analysis there. If we go to 46-26-3 and look at the definition of approved nursing program, we will see that it says approved nursing program in this state means a program that's approved by the board is meeting criteria. That's what Rule 410-8-0.06 comes in. Second sentence, approved program outside the state means an education program that the board has determined meets criteria similar to or not less stringent than criteria established by the board for programs located in the state. That is the equivalency determination that the statute gives the board discretion to make. In that equivalency determination, the legislator goes on to say, there are 4 additional criteria that the education program must meet to be approved. Number 1, we know that his school was not a unit of the University System of Georgia, not an institution for Tech College System of Georgia. C is not accredited, regionally accredited. Here we go. D says that it does not have to be regionally accredited if the board determines the curriculum meets criteria similar to or not less stringent than criteria established by the board. Okay? So it is clear that this statute gives the board discretion to determine the approval status of Mr. DeGrilla's school. So you may ask yourself, how does the board exercise that discretion? They have a policy that they put in place, June 2014, policy 1.13, that references both statutes that we just went over, 43-26-3, and it says it provides the definition of approved nursing education program located outside the state, means a nursing education program that has determined to meet criteria similar to and not less stringent than criteria established by the board. And here we go. For purposes of applications by examination or endorsement, the board has predetermined that any program located outside the state is approved if it's approved by another lawful board of nursing in the United States, which Mr. DeGrilla's school was. So to go back to your question, the board exercised its statutory discretion to deny his application by imposing a national accreditation standard on him that was meant for in-state schools. However, the board was supposed to abide by their policy and approve him if his school was approved by a lawful licensing board in the state where the school is located.
How do we know that either Concord is nationally accredited, so I assume it satisfies the approval of another lawful board of nursing, but how do we know, is there something that says broadly that Carlene is approved by the Board of Nursing, or is this an argument of implicit acceptance because it licensed Mr. DeGrilla with those credentials?
Okay, so I want to be clear that this policy is referencing the approval status that is given by the board in the state where the school is located.
Right. And isn't this school located in Florida?
The school is located in Florida.
Right. And he's licensed in Florida. And so my question is there some document that says the Florida Board of Nursing approves this school, or is it implicit because they allowed Mr. DeGrilla to be licensed even though his his credentials derive from a non-accredited school?
There is a document that says that that school was approved at the time that he graduated from it. And when we filed and I'll tell you, Your Honor, where you can see that document. When we filed our motion to supplement the record, we included that document as an exhibit. Okay? And that is—
I only allowed one of them, right? I allowed your letter. I did not allow the additional material.
Did not allow, right. You did not allow it in the record. But here is the reason why, even though it's not in the record, why we are asking you to take judicial notice of it. The board, as an extra record reason for denying his petition, is saying that they cannot possibly license him because the school is unapproved. I just showed you that they have statutory discretion to make this equivalency determination. And I just showed you the policy which says how they're supposed to do that. So we are responding to the board's extra record reason. So we wanted you to take judicial notice that the policy says that he can be licensed if his school was licensed by Florida. And we have put in the motion to supplement the document that shows you that it was. That document is available to the board.
Was that document, while that document might be generally available to a board of nursing, I assume, given that you asked to supplement your record to include it, it is not a document that was made part of Mr. DeGrilla's record before the board. Is that correct?
Fair question. It was not. And here is why that is immaterial to this argument. Because the board's assertion that they can't grant his approval because the school is unapproved is also not a part of the record. So if we're going to enter—
I'm sorry to interrupt, Ms. Williams. Will you take that screen share down unless there's something else you want to share so I can see everybody? Thank you.
So here's why that's not material to today. The board is making an extra record argument that they can't possibly approve Mr. DeGrilla because his school is unapproved according to the statute. I just showed you how the statute gives them discretion to do an equivalency determination. And I just showed you the policy that says how they're supposed to do that, which is to determine if the school is licensed in the state where it sits. So if we're going to entertain the board's extra record argument, how can we do that without allowing him to defend himself with extra record material?
Thank you. I'm curious, forgive me, Ms. Williams, I'm curious, oftentimes some of these legal arguments sort of bubble up as lawyers spend more time with the record. And I'm curious, if you're saying this is an extra contractual argument that the board is now making, right? That we don't have the discretion, whatever. I do wonder, is your argument, if the board, okay, let me back up. Did the board take into account this policy 1.13 that you're referencing, number one? And if they either did or didn't, or is your answer that you have no idea because they didn't put it in their decision letter?
Okay, so when we filed the petition for judicial review, we had no idea why they denied him because they didn't give us a reason.
Right.
Okay. Now, after we filed, they started hitting us in the court with documents, defending themselves as they should. However, in those defensive documents, in their motion to dismiss, which was essentially their response to our petition and in their briefing, that is when they admit that they never applied 1.13. They say it. They say it in their reply brief. If you want to see exactly where they say it, look at their SIR reply brief. They really talk about it there. They admit that they never applied that to his license application. Why? Ask yourself why. It is an existing policy that is still on their website today. And if you would like me to share my screen to show you how this policy still exists today, why would they not give Mr. DeGrilla the benefit of applying that? Now, what the board is going to tell you when they get time to present is that we are trying to turn this proceeding into an appeal of his license application. We are not turning this proceeding into an appeal of his license application. We are simply responding to their extra record argument that if they cannot, that they cannot under any circumstance grant his petition because his school is unapproved. We want to be especially clear here that what we are appealing is the denial of their rule waiver. We are not appealing the denial of their application. And the only reason why all this application talk is even happening is because the board brought it to the court in their documents in their attempt to try to find an extra record reason for the denial.
Thank you, Ms. Williams. Now you had mentioned there were sort of, well, you've been going for about 15, 20 minutes. Are you at a stopping point? Have you addressed what you wanted to address? Understanding that you are the petitioner, and so you will get the last word in terms of a response to anything that Ms. Souza might say.
I think I'm going to hold and let Ms. Souza respond, and then I'll reserve the rest of my time.
Okay, understood. Ms. Souza?
Good afternoon, Your Honor. Thank you
Good
for taking the time to meet with us today.
Go ahead whenever you're ready.
Thank you. While this case may have a sympathetic set of facts, it has one straightforward legal answer. The board can make several arguments today, but the truth of the matter is that Mr. DeGrilla's petition for a rule waiver to the board did not meet the requirements for a rule waiver. On the merits, while his hardship is understandable, it's not unique, and he has never functioned in Georgia as a nurse, as the statute requires. Furthermore, to meet a petition for a rule waiver, the second part of what you have to show is that you can meet an alternative standard before the court, an alternative standard that will keep the public safe. He independently fails the second prong of this rule waiver standard because he cannot meet that alternative standard. I'm going to start with my rule waiver argument since that is what Ms. Williams wants to focus on. I want to address the merits of the hardship determination directly because even if you reject every single argument that and reach the substance of it, the board's denial is supported by evidence in the statute. OCGA 50-13-9.1b1 defines substantial hardship as a significant and unique demonstrable hardship that impairs the ability of the person requesting the waiver to continue functioning in the regulated practice or business. Three conjunctive elements must be satisfied. The hardship must be significant, it must be unique, and it must impair the ability to continue to function in the regulated practice. The petitioner fails on two of these three elements. While his hardship is significant, it is not unique, and he has never functioned in the regulated practice. He claims three sources of hardship: the cost of repeating an ASN program, the need to take time off work to do so, and the burden of commuting to Florida to work. With respect, these are hardships that every applicant who fails to meet the educational requirements for licensure faces. Every applicant denied a professional license because they lack required credentials would prefer not to repeat their education. Every applicant faces some financial cost. Every applicant would rather earn money as a licensed professional than do something else. That is precisely what the unique requirement is in 5013 9.1b1. And that is what it screens for. And it is why the board properly found his showing insufficient. If this court holds that the petitioner's hardship argument is unique, then the unique element would be effectively read out of the statute. Every applicant could make that same showing. Furthermore, the statute requires that the hardship impair the ability to continue to function in the regulated practice. The Georgia Court of Appeals has interpreted this language in Weckler versus Georgia Board of Examiners of Psychologists, where it held that because Weckler, the petitioner in that case, has not received a license to practice psychology, she cannot establish that the denial of a rule waiver would impair her ability to continue to function in that profession. Mr. DeGrilla has never held a Georgia RN license. He has never practiced as a registered nurse in Georgia. The board's denial does not impair his ability to continue to function because he has never functioned in Georgia nursing.
And so my question, Ms. Sousa, in terms of that sort of a hybrid legal and factual argument, right? I don't think there's any dispute that Mr. DeGrilla has not practiced as an RN in the state of Georgia because he's not licensed. And then the additional factors about whether his hardship is unique, it sort of begs the question that Ms. Williams started with, though, which is where are the factual opinions that you're arguing right now in the board's decision? And does their absence, which I assume based on what Ms. Williams has told me, they're not there in great detail. One, where are they? And two, if they're not there, is it fatal to the board's decision? And does it require just on that alone a remand because the court can't meaningfully determine if the board had sufficient facts to determine that he had never practiced as an RN and had sufficient facts or any evidence to determine that his asserted hardship was not unique?
So I think that's a two-part question, Your Honor. One, I want to maybe correct slightly what Ms. Williams said earlier. The court is not limited to the actual rule waiver denial letter to determine the facts and reasons. The court has the entirety of the rule waiver petition to review. Ultimately,
but if I'm not supposed to substitute my judgment for the board's determination, what am I supposed to look at to understand what the board? I mean, I've reviewed. Admittedly, not sure I understood all of it, right? Because, but I've read it, and I guess my question is, while I might be able to glean some things, it sounds to me like at its most basic, your argument is, for all the reasons that are apparent in the record, we hereby make this decision. And I guess my question is, if that's kind of the argument, that the facts on which the board relied are in the record, and then is the fact that they're not in a letter but are in the record, does that require me to substitute my judgment for the judgment of the board? Because determining what in the application was important to them or not important to them, and what influenced or didn't, and whether, I guess my question is, I need to know, how do I know what they based their decision on other than just the record?
Your Honor, that's a legitimate observation, and I don't want to pretend the letter is a model of APA compliance. But I have 2 points. First, the relevant facts in the context means the factual predicate for the decision. And the decision was that the hardship claims in the petition were insufficient. The relevant fact is that the insufficiency of his showing, and that is stated. Second, whether the letter...
Let me interrupt you. One of the reasons I'm pushing you on this point is if the board's real decision was, we considered all the facts that Mr. DeGrilla presented, and we don't think it presents a unique hardship, so there's no basis for us to waive the rule. That's one thing. That begs the question of what facts were they taking into account, and is that really what their decision was based on? But if their decision is based on this argument that legally he can't even apply for a rule waiver because he has never practiced in the state and therefore that rule doesn't apply to him, that's an entirely different set of circumstances that almost, I mean, it's based on one fact, right? Which is that he's never practiced in the state.
I see what you're saying, Your Honor. I would say that the board considered all of the relevant facts in his rule waiver petition. It was over 100 pages long. The board did not list out which fact, did not list out each and every fact that it considered because it considered the entirety of the petition. I would also argue that, I'm sorry, I feel like there was a second part to your question that I'm failing to answer.
So I'll just repeat it and maybe I can make it a little clearer because I think it was just a lot of talking from my initial question. So I started off by asking about how would I know what facts the board relied on? And I guess my question is, if the board's real reason for denial, the main reason for denial was, we consider the evidence Mr. DeGrilla presented of the unique nature of the burden he was facing. And we said, we don't think that's unique. That really is an evaluation of factual information. And presumably the board would have made some determination as to that, reliant on facts. And so if that's the case, I guess really my question was, is the basis of their denial, it wasn't a unique request? Or is the basis of the denial, he's not entitled to ask for a rule waiver because he hasn't practiced this profession? Because those are two very different reasons. One of them is purely legal based on one fact that I don't perceive as being disputed in any manner. And the other one is a factually sensitive analysis done by the board.
I would say that the board based its decision on both facts, on both the fact that it was not unique and the fact that he had not practiced. Not practicing is the subsequent, it's the other portion of the code section. So the board reading the entire code section, he needs to present a hardship, it needs to be a unique hardship, and he needs to show that it would damage his ability to continue to practice. Those are the three portions of the code section. He demonstrated that he had a hardship, but his hardship was not unique. And it was, his hardship was also, I apologize.
That's okay.
And he, and his hardship was not unique. And he could not show that that the board was preventing him from continue to function in the practice. Ultimately, I would also argue that the denial letters did substantially comply with 50-13 9.1. OCGA 131C provides that substantial compliance with any statutory requirement, especially on the part of public officers, shall be deemed and held sufficient, and no proceeding shall be declared void for want of such compliance, unless expressly provided so by law. Section 50-13 9.1E does not contain a void if non-compliant language. The Court of Appeals has applied this principle directly in Theobald versus the Georgia Board of Dentistry, where the court held that because the APA provision did not specify that an untimely decision was void, and because the petitioner could not show specific harm, substantial compliance was sufficient. The reasoning applies here with equal force. Substantial compliance with 50-13 9.1E's requirement is sufficient where the statute prescribes no penalty for noncompliance and no prejudice is shown. There is another case where the Georgia Court of Appeals has held Georgia Department of Human Resources versus Odom. And in that case, it found that an agency decision satisfied the writing obligation so long as it gave adequate reason for its decision, reasoning that the agency, quote, need not recite every fact and conclusion consistent with its decision, unquote. The May 22nd letter meets that standard. The May 22nd denial letter is in writing. It identifies the governing legal standard, the substantial hardship under 5013 9.1b1, and it states that the board's reason for denying the rule waiver, the specific claims of substantial hardship presented in your petition, did not provide sufficient justification to warrant a waiver of the rule. The letter both communicates the reason for the denial and the factual focus, that petitioner's own hardship claims in a summary form. Under Theobald, Odom, and 131C, that is substantial compliance. The statute does not require the agency to write a judicial opinion. It requires a statement of the relevant facts and reasons, and the May 22nd letter provides both, but albeit concisely. Ultimately,
Very concisely.
Very concisely.
One sentence that is conclusory in nature. What about the section that says the relevant facts and reasons supporting the agency's actions? And so I think giving the board the benefit here that the reason supporting the agency's action, I think, is probably captured by saying that the claims of substantial hardship don't provide sufficient justification. But there's nothing in this letter about actual facts other than a sort of generic reference to the facts he provided, which certainly were before the board.
Your Honor, it does not really state a full list of the relevant facts. However, the board did attempt to communicate what it believed the relevant facts to be, and petitioner cannot show that his substantial rights have been prejudiced. We have had extensive litigation on the precise issue pinpointed in the denial letter. Petitioner had adequate notice. Under OCGA 5013-19H, the court may only reverse or modify if the substantial rights of the appellant have been prejudiced. That is not an optional element. It's a gateway to relief under the statute. Procedural irregularities, even real ones, do not justify reversal in absence of prejudice to the substantial rights. In Quigg versus Georgia Professional Standards Commission, the court found that even if the commission failed to comply with the proper statutory procedures, the petitioner's substantial rights were not prejudiced where notice and full opportunity to be heard was afforded to the petitioner. In Georgia Department of Human Resources versus Odom, the court also found that the relevant inquiry was to whether petitioner could demonstrate that their substantial rights were prejudiced. And how to demonstrate that is by showing harm. Ultimately, the court in that case found that the petitioner could not show harm where the basis for the board's decision is clear. The purpose of 5013-9.1E, the writing requirement, is to provide the petitioner with notice of the basis of the agency's decision so he can intelligently challenge it on judicial review. That purpose has been fully satisfied here. After receiving the May 22nd letter, the petitioner has filed a 16-page initial brief before the court containing an extensive section attacking the board's decision in the letter. After that, they filed a reply brief arguing those same hardship arguments. If he didn't know what the board found insufficient, he would not have been able to target those arguments so precisely. When a petitioner litigates a multi-brief proceeding in Superior Court, squarely targeting at the rationale for the agency's decision, it is very difficult to argue that the brevity of the denial letter caused informational prejudice.
Okay. Thank you, Ms. Souza. Anything else?
Ultimately, I would also say that the burden of showing substantial hardship for the rule waiver is on the person requesting the rule waiver. The letter says the facts that you submitted did not meet your burden.
So let me ask you a question, Ms. Souza, before I hand it back over to Ms. Williams to respond. And it's sort of the same question I started with Ms. Williams, which is, if part of Mr. DeGrilla's argument is this letter doesn't really tell me I understand the argument you've just made that he clearly understood why his decision was denied, or his petition was denied, because he was able to attack it in a very fulsome way in the briefing. But if the court is persuaded that the letter is insufficient, is it the answer to remand it to the board and make them give me a better answer, a better letter that says this is why we denied it?
Absolutely. If the court is persuaded by the petitioner's arguments, the ultimate remedy would be to remand. But even a remand to the board is going to be purely an academic exercise. The board is not going to change its position on the rule waiver because Mr. DeGrilla still does not meet the requirements for a substantial unique hardship. The board can.
I guess the reason, I apologize, Mrs. But I think one of the reasons I keep pushing back at you is I'm going to keep going back to this issue of one of the reasons I'm interested in what the board would say if I said, what was your reason? Is it's one thing to say, we reviewed all of the specific factual information provided by Mr. DeGrilla, and we don't believe it is a unique hardship that everybody else suffers. That's one basis. And that is a very fact intensive and likely one that the court either would or should be more deferential to, because it is an assessment of facts that they are in a better position to understand than am I. But if really their basis is Mr. DeGrilla never was a nurse in this state, and so this statute doesn't apply to him, which this letter definitely doesn't reach out and touch. I mean, it might, because it's one of the items that's in that statute that they're saying you didn't satisfy. That's a legal decision. And that is something that the court it's more important for this court sitting in review to determine if it is a valid understanding and application of the law of the state of Georgia, as opposed to deferring to a discretionary factual review by the actual fact finder at the board level. That's why I keep pushing back on the issue. And I'm not sure, other than a general sense that to the extent you could take that rule and break it down into elements, that one of those elements is unique and he didn't satisfy, which is a factual analysis. And one of those elements is continue practicing, which he also doesn't satisfy. That's really all the sentence says, is to the extent that I have an understanding of what elements you have to satisfy to get a rule waiver, you didn't satisfy them. It doesn't say which one of those elements you didn't satisfy.
I mean, Your Honor, the court is correct. The board did not specifically state which portion of the statute that he could not satisfy. I would argue that regardless of whether the board fully complied with the statute, it did substantially comply with the statute, and that substantial compliance was sufficient enough for Mr. DeGrilla to understand the nature of the argument and to litigate it extensively. I think ultimately, to be granted a rule waiver, Mr. DeGrilla needs to show that he meets an alternative standard, and that alternative standard is sufficient to protect the public health and safety. Under OCGA 5013 9.1c, a petitioner seeking a rule waiver must demonstrate these two things conjunctively. First, that the strict application would create a substantial hardship. And second, that the purpose of the underlying statute can or has been achieved by other specific means. Ultimately, what petitioner is asking you to do, they cannot show that they have satisfied either part of the standard for a rule waiver. Rule 410.8-.016 requires that all nursing education programs be nationally accredited. The underlying statute is OCGA 4326-2, which declares that the purpose of Georgia's Nurse Practice Act is to protect, promote, preserve the public health and safety, welfare through legislative regulation and control of registered professional nursing education and practice. The accreditation requirement in Rule 410.8 .016 directly serves that statutory purpose by ensuring that every nurse licensed in Georgia has completed a rigorous, externally validated program of nursing. Petitioner claims that his alternative standard is this, that because he's completed all of his core nursing coursework at Concord, a nationally accredited institution, the purpose of the accreditation rule has been achieved. That argument might carry some weight if petitioner had excelled at Concord and been denied a degree based on a technicality, but that is not what the record shows.
But doesn't
The
that go
record
to, hang on, I mean, you're the one that said Mr. DeGrill is really trying to relitigate his application. Doesn't saying he wasn't a very good student and he didn't pass the test at Concord, isn't that really relitigating his application?
I am only trying to show that there is a two-pronged portion to a rule waiver, and he cannot meet the second portion of it. The board denied the rule waiver based on the facts that he stated, so that his hardship was not unique, that anybody who needs to travel out of state for work because they are not licensed in one state, but they are licensed in another state, they also face those same hardships. That does not make a hardship unique. But ultimately, there's also a threshold requirement that he has to meet, that he hasn't met for a rule waiver and for its purpose to fulfill what the law requires. The record does not show that he was denied a degree on some technicality. The record reflects that petitioner completed his coursework at Concord with an overall GPA of 2.03. He was placed on academic warning during his enrollment. It's not like he just did not pass the HESI exit examination, which is a comprehensive exam covering the entire nursing curriculum. He failed it.
I understand that. But again, if we're not relitigating his application, right? I don't know that it I mean, call me a softie, but I don't know that there's any value in denigrating Mr. DeGrilla's career academically or otherwise. He's been practicing, hopefully and presumably without incident and with full licensure in another state. So I don't know. I mean, I understand why his licensure, where he got his credentials and the fact that it was accredited or not matters to whether his application was granted. It does not matter, as I understand it, to whether the board would be willing to waive that requirement and let him come in by endorsement because he's already got an RN degree, accreditation and license in another state, which is what the rule waiver is about, correct?
I'm sorry, could you repeat your question?
Isn't the rule waiver, right? Isn't what it's about is that he asked for admission by endorsement because he was already licensed in another state. And y'all said no because this rule says no. And he said, yeah, please waive that rule because I've already been practicing as an RN in this other state and I'm fully licensed in that other state regardless, right? And so my point is, if that's what's going on, then how he got that licensure in the other state, I don't know that matters. And I don't really want to engage. I've read the brief. I am aware of Mr. DeGrilla's struggles and his perseverance to continue and succeed. And so let's just move on from that.
Okay. Ultimately, the board based his denial of the rule waiver on the fact that his hardships were not unique to him, that any person suffering a hardship, any person who has to undertake educational study is going to have to take time and money and patience to do those things. And that applies to every single person who is not licensed in a profession and would like to be licensed in a profession.
Okay. Thank you, Ms. Sousa.
Thank you.
Ms. Williams, your response?
Yes, thank you. So I have 4 points that I want to address. I want to just start off by saying, I feel obliged to say this. Mr. DeGrilla did not grow up in the United States. He grew up in Trinidad. Okay, so him going through a college program in the United States in a different culture is different from someone else. So any attempt
I appreciate, I don't mean to be flip, and I appreciate you wanting to defend your client's honor, but I think I've already said the same thing. I don't know that that is relevant to me. What I see is whether from another country or otherwise, someone who struggled academically but did not give up. And both of
Right.
those things have some merit, but they're not dispositive of the outcome today. So let's move on.
Right. Right. Okay. So I want to address first the concept of remanding this case back to the agency. So Ms. Souza mentioned that, you know, we have had the opportunity to learn through this proceeding all of the board's reasons for denying his petition, and we've had extensive litigation on that. You do not build an agency record through litigation.
Well, to be clear, I didn't understand her to be making that argument. What I understood her to be saying was that the evidence in this litigation demonstrates that y'all did understand why the board denied his claim or his request for waiver, because you were able to attack exactly the things that they were discussing. Now, whether that's winning argument or not, I'm not saying, but I didn't understand her to be saying that they could prove up all the reasons in the litigation, but that your attack and your briefing demonstrates that Mr. DeGrilla did have an understanding of why he was denied. So.
Right. So, and procedurally, when we filed the petition for judicial review, instead of, they didn't even have to file an answer under the statute, but they filed a motion to dismiss in response, and that's where they included all the extra record arguments. So that is how we were able to attack it. It's not like we filed the petition for judicial review and then went directly into a briefing, filing our initial brief. We learned their reasons through their response to our petition. If they had not responded to the petition, we would have not been able to attack it in the briefing. So if the court were to go back and look at their motion to dismiss, you will see where they lay out all of their extra record reasons for denying his petition. You will see that in their motion to dismiss, and that is why we were able to attack it in the briefing. Okay, moving on from that, there's this question about whether his hardship is unique. And then Ms. Souza also mentioned alternative standard and saying he can't meet that. I want to point out to the board that the 4-prong test for petition for rule waiver, the 4 prongs, cite the rule, cite the hardship, cite the alternative standard that was met, cite how that alternative standard protects the public. The only issue in the record that the board took was with the hardship. They never took an issue with his alternative standard. What makes Mr. DeGrilla's alternative hardship unique is the fact that all of his schooling was done at a nationally accredited program. Other applicants may not have that. That is unique to him, that all of the core nursing courses were done at a nationally accredited program and transferred into Carlene. That is how he is unique. And that was articulated in the alternative standard, showing that the board never took issue with. There is nothing in the denial letter that says he failed to meet alternative standard. Nothing saying that the purpose of the statute wasn't met. The only thing that they said was hardship couldn't be met.
Well, let me ask you this, though, because the definition of hardship that Ms. Souza is referencing, it includes multiple different factors, even assuming that you would sort of lump together significant, unique, and demonstrable. Where you really get to what I heard was this issue of whether or not Mr. DeGrilla can satisfy substantial hardship because he cannot demonstrate that it limits his ability or impairs his ability to continue to function in the regulated practice because he's never functioned in the regulated practice in Georgia.
Right.
I'd like for you to address that point, please.
And that will be the last point that I will address. Ms. Souza brought up in briefing and said that he can't continue his profession because he was never licensed in Georgia, and she cites the Welkler case. Again, I just have to perfect the record to say that it's an extra record argument. We're going to just keep that there, but we're going to address it. The Welkler case is significantly different than Mr. DeGrilla's case, and here is how. In Welkler, number 1, the petition was denied in a denial letter that had fact-finding. There was a fact that was found. There's no fact-finding in Mr. DeGrilla's denial letter. In the Welkler case, the fact that was denied was, number 1, the 2004 rule. Do I need to tell you the facts really quickly for Welkler so you can get a context? I can do it quickly if you need me to.
No, I mean, you can if you would like. I'm not saying you can't, but.
Okay. Well, the
It
Welkler
was a psychologist, apparently. That's all I know.
Welkler was a psychologist, went to an online school in California. When she started the school, there was an in-state residency requirement that she read to mean that she could go to an online program. Welkler graduated 2013. They changed the rules in 2010 that said you can't do online programs. Welkler petitioned to have that rule waived as it pertained to her. Board denied it. They went to judicial review. The trial court found that the denial letter said that the rule that existed prior to the 2010 amendment already said that she couldn't do online programs. The board's denial letter said that the court said that there was evidence to support that. So they applied the any evidence rule to that fact. Then they went on to the analysis of continue in profession. Now, here's the difference. Mr. DeGrilla is licensed in the state of Florida and has been practicing as a registered nurse for 3 years in the state of Florida. There is nothing in the statute that says continue in profession in Georgia. You can't read words into a statute. It does not say continue in profession in Georgia. It says continue in profession. There is nothing in the briefing where I can see where Ms. Welkler's counsel ever raised the issue about having a license in another state and working as a counselor as a psychologist in another state. That argument was not before the Court of Appeals. Mr. Welkler is different because we are raising the argument here today, for your honor, that he was licensed in the state of Florida in 2023, has been actively working as a nurse in the state of Florida with no discipline for 3 years with no issues, and he is unable to continue his profession because of the board denying his application.
Well, respectfully, I mean, I don't disagree with you that the court should never read words into a statute that are not there. But I think that in Georgia has to be inferred because Mr. DeGrilla is not limited in his ability to practice his profession anywhere else. He's only limited in Georgia.
So if your honor were to take that position as a policy matter, that would mean that any out-of-state applicant that has a license who applies in the state of Georgia could never show hardship if they can't meet a regulation. That can't possibly be what the legislator meant. And as to take that further, if you go look at the rule registry, which is the rule waiver registry, which is online, you will see where the Board of Nursing has granted waivers to other people. So if they've granted waivers to other people in different contexts, how can they do that if they're saying that the person didn't have a license? In other words, they've given people a license who are licensed in another state but couldn't meet their requirements. They've given them that license. So they have already decided effectively that hardship can be shown if you're licensed in another state. So how can they in this proceeding say that? So if they're going to take that position, that means they can never license someone in the state of Georgia, waive any requirement, because that person would never be able to show hardship because they don't have a Georgia license.
Okay, I understand. Okay. I have a question for both of you now. I apologize, Ms. Williams, with my questions. I sort of hijacked your rebuttal. If you had some other points that you wanted to make, now would be your opportunity. And then I do have some questions to sort of where I want to end on. But I didn't want to cut you off because I did, like I said, hijack your response.
Well, I do want to end on this point. We are asking the court to release an order directing the Board of Nursing to grant Mr. DeGrilla's petition for rule waiver from the rule-based national requirement that is not in the law, it's not a waiver of the statute, and was applied erroneously to Mr. DeGrilla when the policy should have been applied. We are asking the court not to remand this case to the board so that they can use this proceeding to draft some elaborate denial letter that appeases your honor. It would prejudice Mr. DeGrilla severely if that was done. And I want to point out that the board had an opportunity to correct their denial letter when I asked them to do that on May 22nd. I pointed out this issue to them that is in the supplement to the record that I filed this court last Thursday. They refused. So to give them the third opportunity to do that after all of this litigation and all of this hard work that Mr. DeGrilla has done would completely prejudice him. And lastly, I want to end with this. 50-13, 9.1, subsection, 50-13-19, subsection G says, the review shall be conducted by the court without a jury and shall be confined to the record. Shall be confined to the record. If the record was so substantial compliance, Your Honor would not have had all the questions that Your Honor had today.
Thank you, Ms. Williams. Okay, so here's where I want to end. I do want an answer to one question from both sides, and that is this. When I've asked, should I remand because maybe the letter's inadequate, right? The pushback I get, the AG's like, yeah, sure, remand. That's fine. We'll give you a better letter. And even Ms. Williams, your response implies that the only thing that would happen on a remand is that the board would write a better letter. But one thing I'm wondering is part of the arguments that Mr. DeGrilla is making are based on things that weren't directly argued to the board, right? In terms of the argument about whether this is a school that is approved through Florida. I understand you're arguing they should have taken all that into account and it's part of how the board should be working. But I think I understand that those arguments weren't directly made to the board. And so I'm not ruling right now, but I do want to sort of be clear that if the court were inclined to order a remand, the court would not be happy if what I get is a remand long enough for the board to write a better letter and come back to me. I would be expecting an actual effort at providing additional information on behalf of Mr. DeGrilla and the board legitimately considering additional evidence. And the reason I mention that is I agree with you, Ms. Williams. If I just remand and all that happens is the board writes a better letter, that probably is pretty prejudicial to Mr. DeGrilla, given the amount of effort and time and money he has invested in getting to this point. So all of that is background for this. What happens if I remand? Because the answer better not be the board writes a better letter. Procedurally, what happens if I remand? Ms. Souza. You're muted.
I apologize, Your Honor. I went to Zoom School of Law and I still have flashbacks from the feedback that we would sometimes get in class. I try to always mute myself when I'm not speaking so you guys don't hear any background noise.
That's okay. I always say it would not be a Zoom hearing if I didn't have to tell somebody they were muted, so.
Your Honor, the court's two options at this point are to either remand to the board or reverse the board's decision. Reversing the board's decision is...
Hang on, let me stop you. I did not say I was going to reverse the board's decision, and that was not my question. My question is, because I actually have three options. I can reverse, I can affirm, or I can remand. And what I was asking is procedurally, what happens down below? What will the parties all do if the court remands for further proceedings regarding this decision, because I think the record is incomplete or that the letter is inadequate?
Your Honor, I believe procedurally what would happen upon remand is that the board would reconsider the information presented in the original rule waiver. As far as I know, there is no mechanism to later add information to a rule waiver that was not originally petitioned in the rule waiver. And so all of the arguments that Ms. Williams brings up now about policy 1.13 and whether or not the school was approved, those would not be considered because they were never a part of the original record.
Okay, and one other question. Again, I don't know if it's dispositive of any outcome here, so don't take it that way, but not that one should have to do so, but is there some limitation on the number of times that Mr. DeGrilla can seek to have that rule waived or to seek to be admitted by endorsement or otherwise to the state of Georgia?
No, Your Honor.
Okay. So all of this, if I were, say, for example, to affirm the board, he could just turn around and file another application or another request for rule waiver.
Yes, I mean, I suppose
I'm sure he doesn't want to, given the time and expense involved in it, but my question is, can he?
Yes, there is nothing barring someone from submitting an application. You have to pay the fee and submit an application. You know, you have to make sure your application is complete. Oftentimes, the board will reject an application because they didn't pay the fee or they forgot to do the background check. That person is not then, you know, removed from the process of reapplying. You're allowed to reapply as many times as you would like, or submit another petition for a rule waiver.
Okay, thank you, Ms. Souza. Ms. Williams, same question to you, with the added piece of information that Ms. Souza has indicated that she's not aware of any procedure by which the board could consider additional information. I do wonder if the parties can ask to supplement the record when you're in litigation. Is there some reason the parties can't ask to supplement the board record while the board while the case is on remand to the board? What happens if I remand?
Right. So if you remand the case back to the agency and ask them to basically give you a reason for denying his petition, what you would be essentially doing is asking the board to supplement the record with their reason. So having what I see happen from a practical standpoint is that the board would draft some type of response, obviously, right? And then from there, I don't suspect that they will grant the application. And then from there, Mr. DeGrilla, if you keep, are you asking this to say that you would keep the proceeding open, or would you close the proceeding with that and then he would have to file another petition for judicial review?
I'm asking you guys, if by proceeding you mean the one that's in front of me?
Yes.
No, if I remand it, this matter stays open.
Okay.
Because what I would procedurally, I know that part I got, right? Like if I remand the case, then I'm waiting for the board to come back with another, with something in compliance with the reason for my remand. And my question is, it sounds from Ms. Souza as if she doesn't believe there is a procedure for Mr. DeGrilla to submit additional information for the board to consider on remand. Even if the court were to do something like, I order you to remand and provide me with information, including your assessment of 1.13 whatever, or whether I can't think of the name of the school right now. I'm sorry, not Carleen, is an approved school for purposes of that rule. And I guess that's my question. Y'all are telling me that I procedurally, legally cannot or should not do that, or that there is not a way for the board to engage in such an effort if I were to order it to do so?
So if you order the board to, if you remand it back to the board, again, what I am seeing that from a practical standpoint, you would be asking the board to supplement the record with a new denial letter.
Mm-hmm.
So if the board is going to be allowed to supplement the record with a new denial letter, with all of these extra record reasons that they put in this litigation, then Mr. DeGrilla should be able to supplement the record with extra record materials to respond to the board's extra record reasons. The only reason why 1.13 even came up is in response to their extra record reason. Okay. So 1.13 would have never came up in this proceeding had it not been for their extra record reason. So if we're going to remand and have them be able to supplement the record with a better denial letter and more reasons for the court to make a decision, then Mr. DeGrilla should have the opportunity to look at that denial letter and also supplement the record with his responses.
And as a fundamental exercise in equity, I agree with you, Ms. Williams, but as we all know, sometimes the law does not procedurally allow for me to engage in those things. Ms. Souza, perhaps you have some insight.
Well, can I please
hang on just one second. She's waited patiently, and I'm hoping she's going to give me some procedural insight here as opposed to more argument. Go ahead, Ms. Souza.
What happens when a rule waiver is filed is that it needs to be publicly posted.
Mm-hmm.
And so you cannot supplement the record on the rule waiver because a new rule waiver would have to be publicly posted, because people outside of the petitioner and the board are allowed to challenge rule waivers and they need to be able to be seen. So that is why they would not be able to supplement the record with additional documentation, but would instead have to file a new rule waiver, because the new rule waiver would need to be publicly posted along with every other rule waiver the board receives.
Okay. I understand your position on procedure. Yes, Ms. Williams.
And Ms. Souza is correct. And that highlights my point that remanding the case for a essentially better decision letter is prejudicial to Mr. DeGrilla, because they can supplement, but he can't.
Well,
So in other words, let me just, in other words, I suspect that in their denial letter, they'll say what they said in their briefing, which is that they can't waive a statute. The statute says the school must be approved. Mr. DeGrilla would not be able to raise all of the arguments that he raised during this litigation, again, because those arguments, the 1.13 is not in the record, and he never knew that that was the reason why they denied him in the first place. So they will be able to give a reason that he can't respond to. What I would like to do is, Mr. Bazinet is here for a reason. So I would like to give him the opportunity to weigh in on, on anything else about the remand, if Your Honor would approve that.
I don't have a problem doing that. Very briefly, Mr.
Very
Bazinet.
briefly, good afternoon, Your Honor.
Good
In
afternoon.
my many years of doing these types of things, I have some vague recollection of some authority to the general effect that a court sitting in a petition review like yours essentially has the ability to act as the chairman of the board, as it were, and to direct whatever board to do whatever the court wants. Rather than having the court believe me on that piece of authority, because I will admit I am going on my memory and not specific research that I have done for this case, if the court might indulge the parties to either submit a letter brief, maybe get together with the board and discuss what the real law on this is, and let the court know, because my experience tells me there's a real answer, and as I sit here right now, I cannot cite it to you.
Okay. Ms. Souza?
I would say the statute is very clear. It states that the court may affirm the decision of the agency or remand the case for further proceedings. The court may reverse or modify the decision if substantial rights of the appellant have been prejudiced because of the administrative findings, inferences, conclusions, or decisions are, and then there's that enumerated list 1 through 6 that I'm not sure you want me to read through.
I do not. You correctly inferred that, Ms. Souza. So I think I'm not hiding what my thoughts are here, right? Like I think I'm pretty clearly telegraphing. If the letter is sufficient, it's possible that on the record that is here that the board's decision was justified based on what was actually in front of it. And I'm not saying that that would be my ruling. What I am concerned about, though, is this issue of the Rule 1.3 and whether the board actually engaged in that analysis. It does not sound like it was in front of the board or that the board ever actually considered that meaningfully. Or if they did, maybe I just don't know because it's not in their letter. Yes, Ms. Souza.
I just want to be clear that policy 1.13 applies to applications, and therefore policy 1.13 would not have been considered in regards to a rule waiver because policy 1.13 does not apply to rule waivers.
I absolutely understand the ins and outs of all this that I don't understand. I'm going to let Ms. Williams, I'm going to let you say one more thing, and then I'm going to go with what Mr. Bazinet suggested. The only reason I was still talking was to try and give you an idea of what my thought process is. And so the reason I was interested in what Mr. Bazinet was offering is, what does the nice, tiny little sentence, phrase, remand for further proceedings, what does it meaningfully mean? If the court, does the court have authority? And if the court, what actually will happen if the court orders a remand for additional proceedings in light of this authority or that authority in service of a more fulsome review by the board of the various issues that I've heard here today. That's what I'm trying to get to. Ms. Souza, it doesn't sound as if you particularly object to what Mr. Bazinet's suggestion was.
I do not know of a single statute that states what Mr. Bazinet said. I don't know of a single
no.
statute or case authority.
I think he was speaking colloquially in terms of that I think all he was saying is that the same thing you were saying, that if the statute says that I can remand for further proceedings, then presumably that means I can order what the proceedings are supposed to be about or what I want them to consider, as opposed to merely a remand for, as Ms. Williams points out, the board to supplement its letter and make it better. And so I think what I am inclined to do on that very tiny limited issue is ask you and Mr. Bazinet that sentence that gives me the authority to remand for further proceedings. What does it mean? What authority, if the court wanted to remand, what authority does the court have in terms of directing the parties to remand on a particular issue, or for further proceedings on a particular issue, et cetera, right? So that your answer, Ms. Souza, may be that is not, it would not be appropriate despite the language of remand for further proceedings, because the rule waiver is published. It's a closed record for even the board, and therefore there, it is what it is. That might be your answer, but I'm looking for a very discrete answer regarding the scope of what the court can order on remand. Does that make sense in terms of what I'm asking? Okay. The record will reflect that Ms. Souza was nodding.
Yes, I'm sorry for the court
that's
reporter.
totally fine. Realistically, how soon can you do that? Because I don't want to let this sit in terms of what my ruling is going to be, if I want the parties to do something more, or if I'm going to enter a final ruling on which the parties can take whatever action they choose. Mr. Bazinet?
Couple days, I would say, because I have a specific case in my head where language I've seen I'm looking for.
Okay, and understand, I'm not looking for another 20-page brief or even another 10-page brief. I'm talking about a letter brief or even an email with case law or something that you want to direct the court's attention to. I'm really talking about something very finite. Ms. Williams?
I would say, I was just office management in terms of how much time things take. I'm the better person to answer that question. It would take at least a week, not a couple.
And don't worry, I wasn't going to ask for a couple of days because I don't think that's reasonable for any lawyer ever. It is March the 5th. What I would probably be doing is asking for something by March the 12th or March the 13th, which is a week.
Okay, and I think that sounds.
And again,
that would work for us as well, Your Honor.
Okay, and again, I'm talking about 2-3 pages. Doesn't even have to be pages if you don't want to give me pages. You can send it by email, you can send it by letter. I understand if you want to make it part of your record. I don't object to your filing it, but I really do want it to be a particular discrete answer to the question I have asked about what is the scope and scale of the court's authority and discretion on a remand for further proceedings. Okay?
Are you going to be releasing an order to that effect, or?
I will if you want me to. I'd rather not. What I would expect to do instead is once I enter a formal order in this case, and probably drop a footnote that we held a hearing and that I had asked for additional legal argument or briefing on this particular issue. So there'll be a record that I did it. I'd rather not do it by one order unless there's some particular reason.
Okay.
Okay. Okay. So let's say March the 12th, which is a week from today, and no more than 3 pages. If it's a letter, that's single space. That's a lot of space for lawyers to talk. So let's try to stick within that structure. And then I will endeavor to get you a ruling as quickly as I can. I don't want to delay the parties from moving forward, either with Mr. DeGrilla's nursing career or with the appeals or anything else that might need to be filed depending on the court's outcome. Okay. Thank you all very much for your time and your argument. I appreciate your patience with my questions and your very educated and helpful answers to my questions. So have a good day, and I will see you in briefs at some point soon. Okay. Thank you all.
Thank you, Your Honor.
Yes, Madam Court Reporter.
I just need to ask 2 things. One, are the parties splitting takedown?
No, we did not request takedown.
And then would either party like to order a copy?
Doesn't sound like it. I will take this
We
opportunity.
do not need a copy.
Right. I will take this opportunity to mention for the parties that this is my hearings are live streamed on YouTube to satisfy my constitutional obligation to have an open courtroom. But that the recording of that is not an official court record. You can't use it as an official court record, and you can't even have a transcript generated from it to make an official court record. So just throwing that out there. I know lots of lawyers use it as a resource, and I have no problem with that to remind you of something I asked or something that was said. But just a reminder, it's not an official court record under Rule 22. Okay. Thank you all. Or maybe it's 21. Anyway, have a good day.
Thank you, Your Honor.
Thank you. Counsel who are here on the Andrews versus Ebler matter, if you can give me, I know I'm way over time and you guys have been patient. I appreciate it. If you can give me about 5 minutes to just step back, get something to drink and clear my head from that matter and give you my undivided attention reset on this one, I would appreciate it. It's 2:55. I'll be back with you at 3. Okay.
Thanks, Judge.
Thank you, Your Honor.
Thank you. Okay. So a couple of things, just start off with, do we have a court reporter? Because I don't have one, and no, I don't see one. So just want to make sure you understand that there will not be an official record of these proceedings, although I guess there, as I said a moment ago, an unofficial record of these proceedings, because we're all on YouTube. We're all influencers now. So, okay. Here is, I have to say, I have rarely, if ever, been so inundated by so much information at the last possible second. I don't blame the parties in the sense that there was some lack of knowledge, you know, if this was going to be an evidentiary hearing or not. And I've seen some of the email cross traffic that, you know, I think perhaps, you know, counsel for the moving party was right that, hey, look, if the court's inclined to grant some sort of damages, then obviously there would need to be some evidence in front of the court about the nature and scope of those damages and how they arose. But the preliminary question, while I think I understand the parties are in agreement on maybe one topic, which is there's not really a dispute that the satisfaction of judgment wasn't filed within 30 days or within 60 days as required by the statute. But beyond that, right, I don't know that there's any agreement about anything. And so where I sort of started from looking at this filing and trying to figure out what we're going to do with it, it seems to me that if that fact is not disputed, and if much of what I've seen, in granted skimming, but much of what I've seen got filed was actually just copies of what is in my record, and I have on my screen immediately to my right that I am looking at right now and can tell you when it was filed and what docket entry number it carries. And so if that is the record that we are working with, then really the question is there a basis for fees to be awarded? And then beyond that, if the court determines that there is a basis for fees to be awarded, then the court will either inquire further today or ask for additional information in the form of what I think I've already seen, again, skimming only, some affidavits, certainly proffers or representations by attorneys who in Georgia are allowed to state in their place about the damages incurred. And so that's where I think we start with this case. I do want to add one other piece, which is that I have rarely in my career encountered a statute that has 0 notes of decision. And my own personal research indicated maybe I found 2 cases that even reference the statute. And so we are definitely in uncharted territory, except for the fact that, of course, the court generally has an understanding of what the structure of the American rule for attorney's fees are, and the structure, which I understand this statute goes against, and it exists for a reason. And the structure of how and when fees are appropriate. Now, I don't know if it's proper for me to superimpose on this statute something like a 915-14 standard, or even something like a 13-611 standard. But I have to impose some sort of standard. And what I keep coming back to, and this is where I'm going to stop talking and throw it over to the movement to pick up from there and go. Where I keep coming back to is where I think I am most interested in hearing about from the parties is this issue of how and why the satisfaction wasn't filed, and whose obligation it was to do something about it, and whether we're going to call it a mitigation component or not. Is it fair under this plain language of this statute to award any fees, $500 or $5 million, right? For something that could have been remedied. I mean, my initial review is, well, the main damage, there might be some more, but the main damage, I understand it's capped at 500, but you know, it seems like the movements went out of their way to tell me that they'd incurred all these expenses because they couldn't sell their condo. And then there's that larger question of whether this statute even applies, which I think is the primary defense that I've heard from the non-movements here. So all of that is a long way of saying this. I've read I have not read what you guys have been inundating me with in the last 2 days, but I did read the original briefing. I did read the original response. I have gone back and refamiliarized myself with the historical background of this case. I have done some research and reviewed the language of the statute. And so that's the universe that you have to work with. And from there, I will throw it over to counsel for the movement and ask you to take it from there, sir.
Your Honor. And I'm so sorry. I apologize. Could I address just a very brief threshold matter?
Yes.
So, Your Honor, I am here with Reese Farron on behalf of.
Forgive me for interrupting. Is this the Pro Hoc Vice issue?
It is.
Okay. That's an easy fix. I received a motion, an application for Pro Hoc Vice admission for, I know I saw it. I don't remember the person's name. Is it you? It was your name.
Farron. It'd be me.
Okay. Unless Mr. Weiss is going to tell me, or one of you is going to tell me that there's some particular objection, other than the fact that it's not procedurally right yet because you haven't, done all the things, unless you are the same attorney who previously appeared. But other than that, I don't have a problem allowing us to proceed on that issue. I appreciate you reminding me of it before we got too far down the road.
And the other reason I wanted to bring it up is that, so I received an email this morning directly from Mr. Ebler that I need to share with you. Mr. Ebler told me that he had just filed a grievance with the Georgia Bar Association against me. I don't know what it says. I don't know what it's about. But he mentioned that I needed to alert you because the Pro Hoc Vice application does say that and I represent that I've not been involved in a formal disciplinary proceeding, and that is true in Washington and every other state I practiced in. And so it is important that you know that Mr. Ebler made that disclosure to me this morning.
Okay. Mr. Ebler's counsel, if you want to address that, the only thing I'll add is that my understanding of how our rules work is that technically, Mr. Farron, you still are not a party to any disciplinary action because a grievance there is an initial procedure where the bar has to review that grievance to determine if there is cause for them to investigate further, at which point they're obligated to notify the aggrieved attorney. And none of that has happened so far. Is it Mr. Weiss or Mr. McWilliams?
Mr. Weiss. And I'll address that before I go into the substance, because I do have a few things to say.
Okay.
I am not opposing Mr. Farron's ability to testify here or not testify, to appear in front of you, or for the Pro Hoc Vice motion to be granted. I will note that it is a little unusual that this case has been pending for 5 years and Mr. Farron is filed his Pro Hoc Vice motion.
Well, it hasn't really been pending, right? This case was over. But for the 9/13/80 motion that was filed, this case was long over. And granted, the satisfaction should have been filed a long time ago. But I understand your point, but the case was really over. We all functionally know that. There's no reason for a lawyer to be maintaining a Pro Hoc Vice admission when the case is functionally over. But let's move on.
Okay. The only reason I raised that, it will touch on one issue. There's a footnote in the reply that I'll expand on a little bit, about some of the delay may have had to do with the fact that there wasn't a Georgia licensed attorney for a period of time in the case, but I'll talk about that when we get there. On the bar complaint, yes, my client did send an email to Mr. Farron this morning. And
before you go into any substance, I will let you know that the grievance process is confidential between the complaining party, the state bar, and the attorney about whom the complaint has been made. And so I would advise you that I'm not inviting anyone to discuss the nature or basis of what that complaint contained, unless you're going to tell me that it is dispositive or outcome determinative for these proceedings today.
It's not. All I'll say is that my client advised me after he filed it. I was not aware he was going to file it this morning. I have not been retained to represent him in that matter, and I have not communicated with him about that matter. So I have really nothing to share with you because I'm not involved with it. So it's been acknowledged, and I think that's all we need to really talk about. The only thing I'll say, and again, not really knowing the substance, certainly we're not opposing the Pro Hoc Vice motion. We just would ask, I don't want anything that happens today to somehow impact whatever comes out of that disciplinary proceeding. Like we're not waiving any rights. I'm sorry, my client is not waiving any rights with respect to that by not opposing the pro hoc vice motion here. And so to the extent my client believes he has a disciplinary claim, he reserves his right to assert that at a later date and at the appropriate time.
Fair enough.
So with that, we'll go to the substance for why we're here today. All right, so we're here because my clients are judgment debtors who satisfied their judgments with the plaintiffs and were delayed, as you mentioned, for a year in their ability to sell their condo, which is located on Far Court. I believe it's in Buckhead here in Fulton County.
Well, I appreciate that. You've gone directly to the part I have questions about, which is,
Yeah.
and this, I'm asking for a proffer because unless there's an affidavit that I haven't had a chance to read that was filed in the last day, I'm not inviting Mr. Ebler to testify. That's not a road I want to go down today. When you represent that your clients were unable for a year to sell their condo, I have two questions. What efforts did they make to try, and what stopped them? Because one of the non-movements arguments is that even though there was a judgment out there, if they never leaned it or made further effort to execute on it, that there wouldn't have been anything stopping them from attempting to sell their condo.
So OCGA 91280 says that the entry of a judgment binds the property. Oh, sorry, it's 91288. I apologize. Basically says that I'll just read it. In all cases in which a judgment is rendered and an appeal is entered from the judgment, the property of the defendant of the judgment, condo, shall not be bound by the judgment except so far as to prevent the alienation by the defendant of his property between its signing and the signing of the judgment on the appeal.
Right, which begs the question, did the Eblers attempt to alienate their property and were advised that they could not do so? And here's why I ask. Because realistically, in real life, what I suspect would have happened is if there was a meaningful effort to actually sell the property, a closing attorney would have said, are you aware of this judgment? We're going to have to satisfy it as part of the closing. And then this all could have been taken care of. And so that makes me question the extent to which there was a meaningful intention to actually sell the property that was obstructed by the existence of this judgment.
So my understanding is that there was an attempt to sell the property. My client does not currently live in Atlanta. He lives out of the country, in fact. And really, why you asked, why didn't they just satisfy the judgment? The judgment was on appeal. I mean, well,
No, that actually wasn't and if I said that, I apologize. Again, this goes back to my point about there's not a lot of law around this statute. And so I'm trying to work within the parameters of other statutes and common law structures about awarding damages or awarding fees. And one construct is this reasonableness or mitigation, whatever we want to call it. And the first thing that occurred to me when I read your brief is if there had been an effort to sell the property, then a closing attorney would have said, has this judgment been satisfied? And the answer would have been yes. I just don't know why a satisfaction of judgment hasn't been filed. And then this would have all been taken care of and the year would not have gone by. And I know that's probably apropos of nothing because that amount of damages would be capped at $500 anyway. And we'd really be talking about attorney's fees. But it does go to this, while I understand it is the holder of the judgment's obligation under the statute to file a satisfaction, when they didn't, do you just get to sit back and incur damages and fees when the other side, instead of just picking up the phone and saying, hey, file the satisfaction?
So a key factor there, which we did raise in our reply, and I acknowledge those filed 48 hours ago. So
I don't blame you.
I don't blame you.
All
That you
last
didn't have a
minute.
chance to-
I wasn't.
Yeah,
I wasn't meaning to be negative about it. I mean, like I said, it was an open question about how this was going to proceed, and so I understand you guys trying to cover the universe. So
yeah, so that's a very fair question. So if we take a step back and look at the kind of the timeline here. The judgment was satisfied, and we got an affidavit from Mr. Ebler that sort of lays all this out with the email chains and
Well,
but
and
the judge.
sorry, I'm sorry for my continual interruptions, but also my review of my own docket shows that the judgment was satisfied on November the 6th of 2023. And that satisfaction was not filed into my record until May the 6th of 2024, which was a full month after I had entered an order authorizing the case to be reopened so that the satisfaction of judgment could be filed.
So let's go back, obviously, starting with, there's a lot before the judgment was satisfied. There's 2 years of stuff, but let's start with the judgment satisfied. That's April 21st, 2023, which is when the money was wired to satisfy the judgment. The appeals process had already played out in Washington State. So we had April 21st. There was an email exchange involving Mr. Ebler's wife, who's also a defendant in this case, or in this proceeding. And she emailed Mr. Farron and said, please, I don't know the exact word, it was a very short sentence, please satisfy judgments in Florida, Maryland, sorry, it says they needed to release the liens in Florida, Maryland, Georgia immediately. So that was on April 21st, the day of the payment. There was a response.
2023, thank you.
Yes. So there was a response from Mr. Farron, I think that same day. And this is all in Exhibit 7, Defendant's Exhibit 7. And he said that we would wrap this up immediately. And then he sent an email, I believe it was maybe on the 23rd, to counsel there was the Washington counsel for Mr. Ebler. And he asked him to prepare a stipulation. Why he emailed him and not me, who is the Georgia attorney for, I don't know. But in any event, there was an email to the Washington counsel. I guess there was I believe there was no response, and Washington counsel, after the judgment was paid, was no longer involved. And there was from as far as I can tell, I'm not aware if there was any follow-up by Mr. Farron on that topic. During this time, I should note, in the other 3 states where there were judgments or foreign judgments entered, Washington, King County, Washington, Duval County, Florida, and Prince George County, Maryland, satisfactions were filed on May 2nd, May 8th, and May 9th, respectively, of 2023. That's Defendants Exhibits 3, 4, and 5. So we're the outlier. So you go from an email from Mr. Farron on I'd say like April 23rd, April 24th, to the Washington counsel. As far as I know, no response received. And then there's sort of nothing for roughly 6 months. And then Mr. Ebler, you talk about what we did to proactively push this along. Mr. Ebler reached out to Matt Onyet, who was the Georgia licensed attorney on the case, at least in the beginning. And he asked, what's the deal? Why hasn't this satisfaction of judgment been filed yet? And that's Exhibit 8, Defendant's Exhibit 8. The response back that he received, this is November 3rd of 2023, was I no longer represent the Andrews. I'm not counsel in this case. And so tied into that, which is Defendant's Exhibit 25, which we filed, that was the supplemental file this morning. We provided, and we could authenticate it if we needed to, but I know we're not really doing an evidentiary hearing. But it reflects that Mr. Onyet hadn't been with Davis Wright Tremaine since January of 2022. So that's almost 2 years before Mr. Ebler emailed him. And I don't recall ever seeing a notice of withdrawal or a substitution of counsel. So I don't know who was the Georgia licensed attorney on the case during that time period. In any event, Mr. Ebler reached out to him. He said he wasn't involved in the case, but I guess there must have been some communication with Mr. Farron, because in November 6th, which I guess was the following Monday, the process started to try to get the satisfaction of judgment entered. And the order lifting the stay was ultimately entered in April 3rd of 2024. And then the satisfaction was filed on May 6th of 2024. So you're going from April 21st, 2023 to May 6th, 2024 is the period when the judgment had been satisfied, but no satisfaction was filed of record. And so you could say, could we have reached out more often, done something else? Maybe. We did. I think Mr. Ebler did stay on top of it. But at the end of the day, who does the statute require to take care of it? It's the judgment creditor that has to file it. It's not our job to continually prompt them. It's not our job to, facilitate it. They have a statutory obligation under OCGA 91380A to file the satisfaction of judgment. Has to be within 30 days. If it's not within 60 days, it's prima facie untimely.
Right. But so then the question is, what I understand that the primary and I think supplement that I saw is even to the extent that damages, if they're applicable, are capped at $500, that the party can get attorney's fees. But again, having to superimpose what I understand from various different statutory structures about when attorney's fees are reasonable and what they're tied to. And so why, other than a few phone calls, right, before you get to this point, right, where you're not compelling them to file a satisfaction of judgment, right? You're asking for fees, asking for damages. So before you get to this point, why are there attorney's fees other than a few phone calls here or there saying satisfy the judgment, market closed? What's the problem? And also, how do I square that with the non-movement's argument that part of the delay in getting the satisfaction of judgment filed is that you guys wouldn't sign off on the request to the court to reopen the record so that y'all could do all those things?
So I'll answer. It's sort of a two-part question. I'll answer them in that order. So 91380A says that, or sorry, I think it's B4, says the court may award reasonable attorney's fees. And I think that's in connection with the action to recover the damages. So that yes, there were maybe phone calls and discussions up until the judgment was satisfied, but the process of recovering this required filing a motion with the court. It was not an extensive motion. It was a 10-page motion that just laid out sort of the facts and our legal basis. And, we filed.
Generally, not always, but generally, you're not allowed to get fees for recovering fees, right? You can get fees for getting to the point where you're entitled to recover fees, but generally, you don't get fees for spending time to get fees. Am I wrong?
Well, we're not just recovering fees here. And yes, there's a statutory cap of $500.
No, that's not what I'm talking about. What I'm talking about is in the larger scheme of Georgia law regarding the recovery of fees, and federal law for that matter. Generally speaking, you're not allowed to recover if you are the prevailing party, for example, this is something akin to that. You can get fees for the stuff you did to prevail. But you don't get to recover the fees you spent to recover your fees, right? Like you don't get, am I wrong about that? Or is your argument that maybe I'm right, but that doesn't apply here because it's not written into this statute?
Well, just looking at the statute, it's talking about an action to recover on the damages. And it doesn't say, if it was just the process to get to the point where the judgment was satisfied, it doesn't suggest, it just doesn't read that way because you have B, which all of 91380B talks about a private right of action to recover the damages, right? So it says B1, private right of action shall be granted to the judgment debtor upon the failure of the plaintiff to comply with A. Then 2 says the failure, it's the 60-day prima facie thing. 3 is recovery. It talks about how the recovery can be had. Can you file it in this case, which is just the motion on the underlying judgment? Theoretically, we could have filed a separate lawsuit, but for judicial economy, we decided not to do that. And then it goes into damages in B4, and it says damages are presumed at the 100, could be capped at 500, provided, however, the court may award reasonable attorney's fees. So it's all in this context of the recovery action. So I think that the fees incurred as part of the recovery action are certainly within what was contemplated by the statute. And I think you have to look at our statute and not 13611 or 9, what was the other one? 9, 15, 14.
And again,
Yeah.
I agree with you that the court should focus on the plain language of this statute, no question. But to the extent that it is silent in any area, I'm just pointing out that the only place the court would have to reach out to for guidance is Georgia law interpreting other prevailing party type provisions, which is what I interpret this to be, a prevailing party statute, as opposed to a 13.611 or 9.15.14 bad faith or stubborn litigious type statute. But again, it's an open question, and there's no case law to tell me what the court thought the legislature meant. So
I'll add too. I mean, I can't, and I'm not talking about their counsel particularly, but like this was part of a coordinated effort to go after all of Mr. Ebler's assets in 4 different states, and this was posed a substantial hardship to him and his family. And so I can't say why there was a delay here or whether there was some reason it wasn't done deliberately. I don't know. But
well,
I think the fact that there was.
Hang on. I will tell you that my personal rule of life and judging is that I will never attribute to malice that which can be adequately explained by stupidity. And I'm not calling anyone in this case stupid, but my experience is that when people want to infer malicious intent, and usually it's because somebody forgot something or something slipped through the cracks or something got missed. And so I agree with you that we're not going to attribute malice or ill intent to this failure to record a satisfaction of judgment that was properly recorded in every other state where they had pursued. So.
And you had a second part of that question that I don't think do you
and I
recall
think
that?
I've interrupted myself so many times and you that I have forgotten what that second part was. So, so far you're doing fine with addressing my concerns, Mr. Weiss. So I will sort of hand it back over to you if you'd like to head off in a different direction until I come up with something else. So.
Sure. No problem. Happy to answer any questions that you have. All right. So, I think that the general level, you might have seen this and said, it's a $500 cap. Why are they even pursuing it? But the reality is there were damages. There was $15,000 that were caused by for the period of time they were not able to sell. If they went and tried to sell the property, this judgment would have come up in a title search. It wasn't reflected as satisfied. So there were material damages they suffered that under the statute, they simply can't recover most of them. I mean, $500 out of $15,000 is 1/30 of their total damages. So that's why they just want to be vindicated here, and that's why this is being pursued the way it has. So turning to the actual arguments, I mean, 9/1830 is designed to prevent the harms my clients have suffered in this case. It's a 30-day timeline for judgments to be marked satisfied, and it's presumed untimely if it's not done within 60 days. The plaintiffs blew past those deadlines. They waited 5.5 months before approaching me, the defendant's Georgia counsel, about satisfying the judgment. And the satisfaction was ultimately not filed for over a year after the date of the judgment was actually satisfied. Do you have any, I mean, I was going to go through the timeline again. I think we've sufficiently established that at this point.
Yeah, I don't think the timeline is particularly in dispute in terms of that it satisfies the prima facie threshold that's in the statute, plain language, right? It definitely, the judgment was satisfied and more than 30 days passed. And so the statute would apply, and then more than 60 days passed. And so there's a prima facie demonstration pursuant to the plain terms of the statute. Like I said, what I'm more interested in is, let's assume then that perhaps the Eblers might be entitled to some sort of relief under this statute. How do I structure that relief? Because it seems as if, really, I had 2 questions. One is, and I'm glad you mentioned, I'm not sure I actually got a clear answer to that question, which is, was there an actual, was this property on the market? Was there an effort to sell it? Was an offer made that could not be consummated because of some alleged lien? Because again, although you are right that 9/12/88 says that, property can't be alienated until judgments are satisfied, if there's no effort to execute it, I question one, the legal application, which I'm going to hear from Mr. Farron in a moment, but also the realistic nature of the claimed damages, whether they're 500 or 0 or 5,000.
Yeah, I mean, I think the answer is they were trying to sell the property. It was a hindrance in their ability to do so. Mr. Ebler can, if you want, he could provide more detail about that. I know he's not tested. It's not an evidentiary hearing, but we've outlined they tried to sell it. They weren't able to, and they incurred costs during the period when they were unable to sell because they had it affected their title to the property. It was a judgment. It was a judgment that was going to be subject to, 100, the total amount. So I think there's no question that there was this had a real impact on them, and that the damages were suffered, and there was really nothing they could have done to avoid them absent the plaintiffs marking the judgment satisfied, which they didn't do within the statutory time period.
But you're not, other than it attaching by operation of law, you are not disputing that no FIFA was filed, no lien was filed. I don't think I saw a UCC1, and I don't do collections law. I never have. So I might have said a bunch of things that don't even actually apply, but they are things I routinely see in cases where people are attempting to execute on a judgment. I didn't see any post-judgment discovery. I didn't see a FIFA. I didn't see anything like what I would traditionally see where they're actively trying to perfect an ability to foreclose or to secure and recover an interest on a judgment that obviously had been satisfied.
Yeah, and I'm happy to go into that. I think so. I do a lot. I mean, I'm a bankruptcy creditors' rights attorney, so this is very much my space. A UCC1 would be personal property that wouldn't be implicated here.
I fully admit.
But obviously that the judgment was stayed, which prevented the entry of a 5A. And I think that's solely because we did take efforts to mitigate the damage to my client up front in 2021 and 2022 is why the stay was in place. And I think the way Mr. Farron and
the stay was in place because your client was attempting to continue to get the verdict overturned in Washington State Court all the way.
Yeah, we got to stay
whatever
pending
the
appeal.
Washington version of a petition for certiorari is.
But if we hadn't asked for the stay, we wouldn't. I mean, we had to. That was something we proactively had to do back in 2021. It wouldn't have been
right, but it was for the
automatic.
benefit and protection of your client, not to mitigate some 9/13/80 statutory damages.
Yeah, no, I understand that. I mean, it was done. We were protecting our rights against a potential enforcement of the judgment.
Okay.
But separate to that, I think the way the plaintiffs are trying to interpret the statute is to say, well, look, you were proactive about mitigating your damages up front. So because you did that, you shouldn't be entitled to the damages you have suffered because of, how we want to read the language in 9/13/80A. And I think that's a fundamentally unfair outcome too, because we did what we could, which by getting the stay pending appeal, and there were still damages by the fact that the judgment itself has an impact, even if there's no execution. Let me go into that because I do think that's an important point in this analysis is kind of how do you read the statute? So we read it as because the plaintiffs did not satisfy the timelines in 9/13/80A and B2, the defendants had a private right of action. Now, the statute applies even though we can see it on the face, it says that it requires an execution that has been issued before a judgment creditor has an obligation to direct the clerk to cancel the execution. But this doesn't, our position is this doesn't exclude the plaintiffs of their statutory obligations. The word execution it's not a capitalized term. It's not formally defined in any section under the chapter and article at issue in the Georgia Code. We can see they did not file a FIFA, but that's not the only way a judgment creditor can execute on a judgment in Georgia. We cited to the Supreme Court their decision in Black versus Black, which is 245 Georgia 281, where they said you could pursue a garnishment without a 5A. So the failure to file a 5A doesn't preclude certain enforcement actions from being
Right.
taken.
I understand that, but again, all of that is, these are the legal types of ways that you can try to recover a judgment without what we would call a traditional execution. But respectfully, it doesn't actually answer the question, which is, are you, other than by legal operation of law that the judgment attached, right? Are you disputing that they never undertook any effort to execute on this judgment?
Our position is that 91380A applies because the entry of the judgment itself has a impact on my client's property interest.
Understood. But that's by operation of law under 91288 and not necessarily by any affirmative action undertaken by the Andrews to execute on that judgment.
There was a stay in place, so they could not take other actions to execute on the judgment.
Okay.
So continuing with respect to liens on real estate, which is what we're really talking about here, a judgment becomes effective when it's reduced to writing, signed by the judge, and entered by filing it with the clerk. And that's Watkins versus Citizens and Southern National Bank, 163 George App, 468, a 1982 case. Now you have to distinguish that, which is the entry of the judgment, from the entry of the judgment or FIFE on the general execution docket or other similar property records. And that it's simply a process of perfecting the lien against the real property of the defendant. So I see this a lot in, real or personal property. You have the sort of the lien, and then you have the perfection of the lien. The lien is the judgment. The only real effect of the FIFE in terms of enforcement is that it becomes, the Andrews would be superior to any other party, third party, once the FIFE is issued, because it's an announcement to the world that there's a lien. But if you review the docket for the Eblers, there's still the judgment. So it addresses perfection. It doesn't address just the mere existence of the fact that there's a lien on the property.
And I guess, again, I think what I keep, and I apologize, Mr. Weiss, but I think what I keep coming back to is, practically speaking, if Mr. Ebler had gotten an offer and accepted that offer and attempted to close, the only thing that would have happened is the closing attorney would have said, title search shows there's this judgment. Is it satisfied? And the answer would have been yes.
But that wouldn't, Your Honor, respectfully, my client's representation to the real estate agent or the title agent or whoever else was investigating it when there's something on the docket.
Forgive me. I agree with you. That wouldn't suffice. But the time period that I understood during which this is all happening is at a time when the judgment, in fact, was satisfied, right? That's when the damages could only arise under 91380 if the judgment was satisfied but not recorded and therefore gone away. And so my point is, practically speaking, if you play this out the way it goes, all that happens is it gets brought up to the Ebler's attention, and then the Eblers say, yes, it is satisfied. And then somebody files a satisfaction. Maybe if they delay at that point, there's a problem. But at that point, that's what I'm struggling with. It is the practical reality of, I don't know what bucket to put it in this statute, but the practical reality of how is there damage if there was not an effort to enforce a judgment?
Well, the mere fact of the judgment is what caused the damage. It's not, I don't dispute they did not try to enforce it because they couldn't enforce it. And to your point, you're asking.
No, maybe it's a strict liability statute, but generally speaking, one has to apply the general elements of causation and damages. And you can have wrongful actions that don't result in they don't proximately result in damages. And that's really what I'm asking.
So I think we're getting maybe a little too tied up in the damages part of it. I think it is a strict liability statute. It's $100 is the guaranteed damages, but you get to establish up to $500 of your damages. His property taxes and the homeowner's insurance alone, we were well in excess of $500, unless you take the position that none of it was needlessly incurred. And I don't know, I mean, I'm not sure what else you would have had him do. I think that, they were trying to sell the property. He reached out, the 6 months went by. He reached out to plaintiff's counsel to ask for it to get taken care of. Then from November to May, I mean, that's another 6 months after he reached out before it was even entered. So I don't know. I don't think you're going to find, again, there's no case law interpreting this, but I don't know. I don't think he had to reach out multiple times to tell them to do it. I think they reached out the day it happened and said, get this taken care of. It didn't happen. Then they reached out from April to November. So that's 7 months later. And Mr. Ebler said, why hasn't this happened? Take care of it. And then it didn't get resolved for another 6 months. So I'm not sure what else that he needed to do to show that he was trying to get this taken care of. And it's not even, the statute doesn't even put the onus on him. It's on the plaintiff's counsel. And I think, to go back to your core question about what are the damages, I think if you're trying to sell the property and people are being dissuaded and they're saying there's a judgment against you and that it attaches to your property, what can you do about it? All you can do is ask them to satisfy it. And he did. They did twice and they didn't do it. So I just don't know what else you would have him do to qualify under the statute.
One more question, Mr. Weiss. In terms of the assessment of reasonable attorney's fees, what is the time frame of the attorney's fees that you are seeking? Like, when did those reasonable fees incurred as a result of the failure to satisfy the judgment? When did they begin and when did they end?
So the fees that we presented started in May of 2024, which would have been, I think, once we started trying to address the aftermath of the fact that this judgment wasn't timely satisfied. I was not involved in the email conversation in November of 2023. So I think at that point, I think probably to mitigate fees up until for much of this time, I was not heavily involved. But when it was presented that this judgment's not satisfied, they then came to, I think it was November 2023 when they started the process. They wanted a consent motion. They wanted a stipulation. I told them to just file a motion with the court, which is I think that we're not under an obligation to consent to anything. I think it arguably would have waived my ability or my client's ability to bring this claim potentially for the untimely satisfaction of the judgment. So, but we didn't oppose the motion. We just said file a motion. They did. They got the stay lifted, and then they waited. They got the stay lifted April 3rd, the order you entered,
right?
And then they waited another month to file it. And Mr. Freehoff had to send him an email and say, this is pending on, this was Mr. Farron, the plaintiff's exhibit 10, where they said, this has been pending since April 3rd. What's going on? You need to get on this. So your staff attorney has previously acknowledged that there were issues with diligence here. So, the fees we're trying to recover for start in May of 2024 and go forward. So it's really everything relating to the bringing of this claim.
Okay. Anything else, Mr. Weiss? You are the movant here, so I'm going to let you have the last word. But at this point, I was going to transition and hear from Mr. Farron for a bit. Is there anything else you want to say before I do that?
Well, do you have any other? I mean, I'm happy to talk about, to the extent you have questions about 91380A and how it's construed. We did mention, and we attached to my client's supplemental affidavit, the Georgia Council of Magistrate Court Judges had put out a sort of informational sheet about the statute and filing satisfactions of judgment based on its interpretation. And this isn't just a random group. It's the Georgia Council of Magistrate Judges. So they deal with this all the time. And if you look at the language there, and I'm happy to quote from it. This is Defendant's Exhibit 6. It says, the law requires a judgment creditor to file a satisfaction judgment with the clerk of court upon receiving payment in full of an outstanding judgment. So that's pretty straightforward. Failure of the judgment creditor to properly have a civil judgment marked as being satisfied may subject the judgment creditor, the attorney for the judgment creditor, or both to penalties up to $500. The form should be filled out with our clerk when the judgments are paid in full. And then it says, upon payment of the entire debt upon which a judgment or FIFE has been issued, so denote the or, as the judgment or FIFE, the judgment creditor shall timely, within 60 days, direct the clerks of the appropriate courts in writing to, 1, cancel the writ of FIFE if a writ was issued. So they clearly contemplated a situation like here where the writ wasn't issued. And then 2, mark the judgment satisfied. So those are sort of two separate requirements under the statute. And even if you don't have to do one, which is canceling the FIFE, you still have to mark the judgment satisfied. And so, I would view this, that's not law, but I would view this along the lines of something like an attorney general's opinion from, an entity that's deals with this statute all the time and has issued how they interpret it. So I think that's certainly persuasive. I think there's another argument that's been made that we somehow, that the court orders staying the execution and closing the case relieve the plaintiffs of their obligations under the statute. If you look at both of those orders, there's no such language that could be inferred from that. Even if the case is,
I will point out the one part of this that I did actually take and go do something with is that it is a long-standing disagreement that the court has with the clerk about whether or not you can file something into a closed case, because obviously if you need to file a satisfaction of judgment, obviously the case is closed because I've entered a judgment. And so that is something that we're talking with our clerk about, practically speaking, and its import for people. So at least there's that, but I don't know why that was. I can assure you that that was something that came from the clerk's office and not from my office.
I understand that. And I think both sides had to deal with it. But they talk about that shouldn't excuse anybody's statutory obligations, because you can always file a motion to reopen the case. They did in fact do that. We had to do that when we wanted to file this motion. So I don't think you could reasonably read any order you entered as excusing them from their obligations under the statute. And I think that's generally, I don't think you could enter an order unless the statute authorizes you to excuse them under the statute. And I don't see that in 9/1380. They also argued that they acted promptly based on when the stay was lifted. If you look at the statute, the timelines are clearly based on when the judgment's satisfied, not when a stay is lifted. So I think that really under any interpretation of the statute, they were untimely. They were untimely from the date the judgment was satisfied.
Again, I don't really think that's in dispute, and I don't think that the month that passed is dispositive of anything. I think what matters is that and there's no dispute that well more than 60 days passed from the time the judgment was satisfied until something happened. And more importantly, from my perspective, until anybody even tried to do something, right? So the fact that there was a subsequent effort made to lift the stay so that the satisfaction could be filed, and then that took a while and the court entered an order and then it finally got done. That's all kind of irrelevant, because ultimately the 60 days that's relevant under the statute, I think, had already passed before any of that started. So
yeah. So just in closing, I was going to talk about damages. It doesn't seem like you want to discuss that today, so I will spare you that. But I'll just say, I think if you look at, who is trying to push this along, it was us. It was us in April of 2023, and it was us in November of 2023. And for whatever reason, it just wasn't a priority for the plaintiffs, and it dragged on for over a year. So I think we're entitled to damages under the statute. We meet the $500. I think we well exceed it, but as at a minimum, we can establish $500 of damages, and the statute says we're entitled to our reasonable attorney's fees, and we believe we can have a conversation about what that means if when the court would like to do so.
understood. As I think I maybe didn't say it initially, but I think what you have correctly inferred is what I'm trying to do is figure out if we need to get past the threshold issues. And then once I decide that, yes, we are going to have to get past the threshold issues, then I'll have more questions about what do those damages look like, and are they valid, and what do those attorney's fees look like, and are they reasonable, and et cetera, et cetera. Mr. Farren.
Thank you, Judge. And thank you also for permitting me to appear in this court. And Fulton County Court is it's a well-known court. We read about it in the news, so it's a pleasure to be.
I try to stay off the front page, but that's just me.
It's a pleasure to be here. So, Your Honor, I want to answer a couple of questions that you asked actually about what could have been done with respect to the judgment. So, the first thing is that if the statute is correct, there's a provision in 913.080 sub E that says, look, if you don't get a satisfaction, you give notice by certified mail or overnight delivery, and you get no response within 60 days, you can, with an affidavit of the attorney for the judgment debtor, have the judgment satisfied yourself. So it doesn't leave the judgment debtor without any remedy whatsoever. And it is true, and Your Honor, you're correct, we don't dispute that more than 60 days passed. What we also know, though, is that, with all due respect to counsel's comment that, they did everything they could to move this along, we did get, I think, sometime in the spring, before the summer of 2023, information about payment. We got the satisfactions of judgment filed in Washington right away, in Florida right away, and in Maryland, because the plaintiff, or I'm sorry, he was the plaintiff in the underlying case. The Eblers sued my client in 2019. So, but the Eblers own property in all those various states, and from the record, there's communication in which I point out to counsel that we recorded those satisfactions, and what I was reminded that there was a stay in effect in Georgia, and it was a stay at the request of the Eblers. And in fact, there was a case closure order, and that we would need to lift that stay. And so I did communicate back to Washington counsel, can you see what you can do about getting a stipulation? Well, I never heard back from him. My recollection is he was either terminated or that relationship ended. I didn't hear anything more. And with respect to who was counsel of record, apparently Mr. Onyett was still counsel of record. Now, I actually didn't know that he had left the firm in 2022. This case was stayed, and so none of my work was done or our work was done in Georgia. We were fighting the battles in Washington. After the trial, it was the appeal, and then the petition for cert in the state Supreme Court. And so, unfortunately, I didn't know that he'd left, and that's a problem internally, and that may have caused some of this delay. But but as of November of 2023, Mr. Onyett was still counsel of record. So so Mr. Andrew actually did have an attorney. Now he ended up saying, like, I'm not going to represent anymore, but he didn't file notice withdrawal. As soon as I found that out, what I did is and we have a few Georgia barred attorneys in the firm, and so I had asked Mr. McWilliams to be the sponsoring attorney and help me take the next steps to getting this judgment satisfied, because I was, frankly, after that much time, after 6 months, it was embarrassing to me that it hadn't been done. And so my response was, let's get it done immediately. So we then approached, well, what we did is Mr. Andrew signed a satisfaction of judgment. So that document was signed. It was prepared, ready to be filed. And in Exhibit 5, what you'll see is my communication to Mr. Weiss. And I don't know that I dealt with Mr. Weiss a lot. Mr. Onyet had dealt with him initially because he was the one who filed the original judgment, and my colleague Lauren Dorset did. I don't think it was until sometime in 2023 that we began to communicate. But then I said, look, and I actually didn't know that he was, whether he was still representing his clients because it was Mrs. Ebler who reached out to Matt Onyet at that point. So I didn't know whether.
Let me save you some trouble, Mr. Farron.
Yeah.
I am unbothered. I know that it's been brought to my attention. I am unbothered by whether you had a proper local counsel designee, particularly given that it was someone in a firm and that, things happen. There wasn't any action being taken. And when action was taken, it was taken, I believe, by someone who was authorized to take such action. And so I don't know that I need that history.
Right.
Especially because, again, I also don't think it's outcome determinative of anything. What I think I've made clear, the timing is absolutely in favor of the Eblers here in terms of the fact that the satisfaction was not filed within the requisite 30 days, and then within beyond that, the 60 days that are referenced in the statute. What matters to me is some understanding of why that occurred. In terms of once you realized that the judgment hadn't been filed, what steps did you take to get it filed, and why was that unreasonable, which I believe is partially Mr. Weiss's argument. And
well, Your Honor, I'm not going to dispute that it took us from at least say May to November when the Eblers contacted Matt Onyet, and then he contacted me and said, hey, I've been contacted by the Eblers. And I said, well, can you help do this, finish it up? And he said, no. So I said, we're going to, we have to do it. And so, but in that 6-month period, I think, frankly, it was just that I'd asked local counsel locally for a stipulation. We believe we believe that the case, that the stay had to be lifted. And as it turns out, we could not file a satisfaction of judgment. It simply could not be filed. In my email of November 9th points out that we had, the Fulton County Clerk's Office would not accept the satisfaction of judgment.
right.
If
If
I
you
was
had gone
rejected,
in the system and filed it, it would have been rejected.
case is
It
not
probably
available.
was.
Right.
And someone communicated to you that the case was closed and they would not allow. I'm aware of all that.
So it was physically impossible to file a satisfaction of judgment. Now, what do we do at that point? So what we did was, so the obvious solution is we then file or seek to reopen the case, lift the stay and reopen the case so that we can file this thing. So what I did is, with Mr. McWilliams' help and guidance, we prepared a stipulation, and the stipulation is stipulation order reopening case and lifting stay. And I reached out to Mr. Matt Weiss as soon as I could, and I said, do you still represent Jonathan Ebler? He contacted Matt Onyet, and then I said, we tried to file this thing, we couldn't, and then finally I said, within a matter of, within a week or two. So here's we prepared a stipulation, and here's a stipulation order lifting the stay. If you sign it, we can get this submitted to the court, and we can get the stay lifted immediately, right? There's no notice period. It comes to you, and I would imagine, Your Honor, when you get agreed orders, they're easy to enter. And so the response I got when I discussed it with Mr. Weiss, and I confirmed this in an email on the 17th, as I said, again, I would really appreciate your signing onto the stipulation we prepared, which achieves the result of a motion to reopen at less cost and quickly. I understand from our conversation that your client is unwilling to authorize a stipulation. If there's a change of mind in the meantime, please let me know. I attach the stipulation again. Here, it will save what seems to be a needless added expense. Have a good weekend. And the response was, thank you for your following up. As we discussed, I do not have authority for my client to sign the stipulation order, so please proceed with a motion to reopen the stay. It then took 4 months because we filed that motion with a fairly short time frame after that. So that was in November. The order, Your Honor, was entered April 3rd.
April 3rd,
Yeah.
2024.
And there's a natural, time period because you're not going to enter orders until there's the notice period, the notice for responses and replies, and I can only imagine that Fulton County is a very busy court with a very busy docket, and so it took 4 months to get that lifted, and Mr. Freehoff did say, counsel, it's been on the docket. Here's the order, and my apology that it wasn't entered, sooner than a month and a few days after that. We had not seen the order before, and I was not regularly checking the docket. Maybe I should have been checking the docket regularly, but we'd not seen the order before. So once I saw it, we did then promptly file satisfaction of judgment. So once we got back on track in November, we really did try to act reasonably. But back to so I guess my point in all this is, and maybe this goes to damages too, but if Mr. Ebeler incurred all these damages, and he keeps saying that they incurred damages for a year-long period, why is it the case then when I asked them, would you stipulate to a lift of stay so we can get this done quickly? He said, no, I'm not gonna agree. I'm not gonna agree to a lift stay. You go do it on your own. And it ends up taking 4 months. And now he places that those costs at our feet for that purpose.
Mr. Farron, I apologize for interrupting you.
Yeah.
I need to interrupt you for just like 3 minutes. If I could interrupt the hearing for just a moment, I'll be right back with you.
Okay.
Okay. I'm going to wait for Mr. Weiss to rejoin us. I apologize for that interruption. There we go. Mr. Farren, please continue. Again, I do apologize for the interruption.
Oh, no worries, Judge. So again, my points were that the judgment could have, the judgment debtor could have taken steps within about 60 days to have the judgment declared satisfied following the procedure that they say applies. According to the procedure in 91380, it obviously wasn't as much a concern when Mr. Ebler declined to agree to lift the stay, which prolonged, we now know, 4 months, the time it took to actually lift the stay and file a satisfactory judgment. And you know, the one problem that we have here is that defendants are saying that we have an obligation, a strict obligation to meet a deadline within 60 days that the file and the court logistics establish could not have been accomplished. So if we're held to a pure 60-day standard, if a satisfaction judgment could not have been filed in this court because the case was stayed and closed and the system rejected those filings, and it would have taken anywhere from 2 months to 4 months to get to the point where it was open. How can the law apply to hold a judgment creditor responsible for an act that can't be performed? So I do think the argument we made is there's an appropriate tolling or equitable tolling that is appropriate here. Your Honor, with respect to damage, you asked a lot of questions that were similar to the questions that we had about why were there expenses incurred in this case when, and Your Honor was correct that, and I think there's a statute that I would point to, 91286, which specifically says no judgment, decree, or order any writ of fieri facias issued pursuant to a judgment, decree, order of the court shall in any way affect or become a lien upon the title to real property under the judgment or writ of FIFA until it's recorded in the office of the clerk of superior court. So there was no lien on his property throughout this time period. It's undisputed that we did not record the judgment. We did not obtain a writ of FIFA. We did not record it on the general execution docket. And one of the reasons is that very shortly after we filed the judgment, merely filed it, they asked for a stay, and we consented to it. It was a consent order. We didn't object to it. So it was physically impossible to have done that. So there was no lien. The evidence on damage that resulted in these expenses is that I couldn't sell the property, but there's no indicative, no evidence of a listing, no evidence of communication with a broker, a listing agreement. For that matter, we don't know whether he still owns the property, which I think the assessors board would establish. But I didn't see that the proof was sufficient in that regard. But let me address the core argument on the statute, and this is so when we saw this motion come up, and it's a motion for $500, recovery of $500, and in the court's discretion, statute says the court may award fees. It's not a fee shift, not a mandatory fee award statute. But the damage presumption is 100. If you're over 60 days, it's capped at 500. So we didn't think this was going to be a big case. I had no idea that we'd be buried in as much paper as Your Honor mentioned at the outset, and that we'd be staring down a fee affidavit of $12,000 before I think as of the reply brief, and I have no idea what it would be, what it will be today. And Lord knows what it would be if there's another evidentiary hearing. And I would ask Your Honor to help us all resolve this case and end this case. I know I'd written emails in the past asking counsel and frankly the court that let's get this done and move on. And I would still like to get it done and move on, notwithstanding the grievance that I will be addressing. But when I looked at it, not only did we have the issues with the case closure, it was a statute that by its own terms does not allow the relief they're asking for. The statute is crystal clear. And I know the court's read it, but the private cause of action that exists in B1 and B4 exists only if a plaintiff fails to comply with the provisions of A. So you've got to meet the test in A. And then, so the question is, does A apply here? And there are clauses in A that are unmistakably clear. 913-080 subsection A says, upon the satisfaction of the entire debt upon which an execution has been issued, the plaintiff in execution or his attorney shall timely direct the clerk to cancel the execution and mark the judgment satisfied. So the legislature included the clause, the 7 words, upon which an execution has been issued, for a reason. It could have left that out. It could have simply said, upon the satisfaction of the debt, cancel everything, cancel the execution, satisfy the judgment. But it specifically included the language upon which an execution has been issued. So that is conditional to the operation of 913-080A. So that's the condition or the event that has to occur before this statutory penalty or damage is imposed. And second, it identifies who is charged, the plaintiff in execution. Doesn't say the judgment creditor, it says the plaintiff in execution. As we've established today, there was no execution. That's undisputed. So there was not an execution that qualifies under subsection A. There was argument that, well, a judgment and execution are similar. No, they're not. And Georgia court has made that crystal clear in the Oxford case we cited, 1959. The court specifically said execution and judgment are not synonymous. Another court had said, and this is the Bowers case in 1984, the court said a judgment is the decision of the law provided by the court and then entered in the court docket. In Oxford, when the court said execution and judgment are not synonymous, the court said the execution issued on a judgment is the means by which a judgment is given life, force, and effect. And like Mr. Weiss, I've spent a fair amount of time doing collection work. And what you know is that the difference between a naked judgment and an execution is an execution all of a sudden transfers power to the state to do something. Execution allows, as we read just a few minutes ago, it allows for a lien on a parcel of real estate. It allows seizure and execution and levy on assets. That's a distinction, and that's the distinction that the legislature was making in this provision.
Okay.
So, and I just briefly say that the only way the court can reach the defendant's conclusion is to rewrite the statute, and the courts have said when under the separation of powers, the court does not have the authority to rewrite statutes. We consider the meaning of a statute. We presume the legislature meant what it said and said what it meant, and that's
Judge Dillard's favorite
all
refrain.
That's what we're asking here. So in terms of fees, if I can address that just briefly.
Yes, sir.
So, I never thought I thought there's a simple, straightforward matter that we could dispose of quickly. It has not turned out that way. Again, the court may award fees. The sheer size of the fees already is not proportional to the $500 damage cap.
Well, we have lots of statutes that allow for recovering attorney's fees if it took attorney's fees to recover your proverbial pound of flesh. And I don't have a problem understanding and accepting that if the legislature intended it to be capped at some $500 amount, then it could have done so, but it specifically carved out an exception for attorney's fees. And that's not outside the realm of what has traditionally been done with attorney's fees, even where nominal damages are awarded when you're talking about prevailing party issues. So I understand why one might look at it and think, why am I getting a $12,000 bill for a $500 potential damage award? But, you know, I think the statute allows it if it's reasonable. And that's really what I'm more interested in, is whether or not those fees are reasonable.
Right. And this is not a prevailing party statute, right? So this statute, because we wouldn't get fees if we win. So, it's also not a fee shifting statute, and it's not a mandatory fee shifting statute that forces Your Honor to award fees. There is you get to use your discretion and good judgment, Your Honor. So and it's, you know, the problem too is that we can't get out of the case. It's, you know, it's difficult when you expect to address a motion on relatively narrow issues or simpler issues. We filed our action in this case has been to file a 7.5 page brief, which I thought was straightforward, but we are now staring down a $12,000 fee request and substantially more. So, but Your Honor, I also don't know that the defendants have fully answered your questions about how they ended up incurring the damages they incurred.
Thank you. Mr. Weiss, it is your motion, so you get the last word. Go ahead.
Thank you, Your Honor. I think, you know, we've talked about, you know, why we think our interpretation of the statute makes the most sense. Their primary argument seems to be that we didn't do enough to mitigate the damage that they caused. And let's be clear, they're real damages. And let me elaborate on my earlier discussion. And this was a judgment that was filed on the record, publicly accessible. Anybody does a search of Mr. and Mrs. Ebler and they, you know, finds this lawsuit, reviews the docket, sees the judgment. Judgment was for, I think, $365,000 or thereabouts. That is well in excess of the value of their condo. And they did have experiences. Obviously, it's not an evidentiary hearing, and, you know, we could delve into it more to the extent the court wanted. But I mean, they confronted real estate agents that wouldn't, or my understanding is that there were real estate agents that wouldn't list it based on the judgment. There were banks that they couldn't get loans from because of the existence of the judgment. So those are real,
right,
those are real impacts, right?
Let me say this. You're right. Those are all real impacts. But what matters is when those impacts were occurring. Because if those impacts were occurring before that judgment was satisfied, then those impacts are the fault of the Eblers because they owed the judgment. If the impacts were occurring at a time after the judgment was satisfied and before a satisfaction was filed or something was done to reflect that that judgment was satisfied, then potentially you're in the universe of this judgment. And so the reason I've stayed away from that factual issue is because I think the timing is going to be a real issue here. And I don't want to go down that road in terms of additional fees, costs, et cetera, blah, blah, before I figure out if this actually qualifies as a judgment upon which execution has issued, or whatever the particular language of the statute is that would entitle him to, because as I think I've already said once, but it merits saying again, if the statute applies, I don't think there's any dispute. I haven't heard any from Mr. Farron. He's fallen on his sword and acknowledged that maybe there were reasons that it didn't get filed, but at the end of the day, it didn't get filed. within the time contemplated by the statute. So the primary question is, does this statute apply in this particular circumstance? And the issue of whether we get to those damages, I mean, you can state in your place and I can look at affidavits, but yeah, I'm gonna have questions about when and how those things actually were incurred, because I'm sorry, but if real estate agents said, I won't list your property because there's this judgment out here that's more than the value of the property, the answer is, well, I still owe it, or I've already paid it off and I can get proof. And that is a factual distinction that matters significantly to the credibility of the argument that is being advanced by Mr. Ebler. And I don't want to have to delve into all of that if I don't have to, if only to avoid the cost and headache that will occur for everyone. So
It's fine. We can drill down on that if you determine that we need to. But going back to the statute itself, and like I said, the whole discussion about the consent motion versus stipulation, all that was 6 months after they were required to file it anyway, so it really doesn't matter. They didn't meet the 60-day deadline. They don't take issue with it. The fact that there was a stay in place. Again, they could have filed a motion the day after the payment was made. They didn't do it. So there's just no question that the timeline wasn't met. And I'll also mention that with respect to the reach out to Washington Council, in addition to inexplicably not reaching out to me, I think the request was for our Washington Council to prepare the stipulation. There's really no reason why they needed to do it as opposed to the plaintiff whose responsibility this is. That probably also would have resulted in delay. Where if they had just filed it, they really didn't need our lawyer's permission to file a satisfaction of judgment in Georgia. They could have just done it. And then the last thing I'll say on that before I go back to the statute, which is the crux of the matter, is that I think you got a concession here that whether inadvertence or whatever, there was just a disconnect about who the local counsel was and whether they worked at the firm. These were all people that worked at the same law firm, so I think the sympathy for it goes only so far, even at a big firm. And the fact that, to the extent that it did result in a delay, it caused, or we argue it caused damages to my client. And, I don't think that's a very sympathetic position for them to have, that there was some oversight on their part within their firm that resulted in this not being done more quickly. So going to the statute, I think, because of the way the judgment statutes work, and this is an old statute, this was first adopted in 1933, which is amazing that there's no case law. Maybe, I don't know if it looks like there's been amendments, but in the original, based on my Lexis, that's the first version of the statute.
Westlaw says the same, Mr. Weiss. So.
Okay, I'm glad I'm not going too far out on a limb on that one. But the idea here is that you've got a judgment debtor, they've made their payment, and they should no longer have to suffer the consequences of it in the public record because they've made their payment. And you can make a distinction. Yes, there was not a 5A filed. Is the 5A decisive for the ability for parties to execute or act on a judgment? No, we cited cases that say that. We've also cited OCGA 9/12/88.
But could and did are relevant for purposes of the application of the statute, right? The statute doesn't say upon which execution could issue. It says upon which execution has been issued.
Well, I think if you look at 9/12/88, which restricts the ability to alienate the property, I think that is a form of an execution. It's self-executing. It doesn't require the plaintiff to take some additional step, but it certainly impairs my client's rights with respect to their property. So I think it's baked into the statutory scheme. And he talks about 9/12/86, which says there's no lien until recording. But again, the plaintiff's counsel ignores the fact that the mere entry of a judgment itself has a legal significance, even if it is not a 5A that perfects it. If somebody files, there's a bankruptcy file, even if it doesn't affect how the judgment creditor interacts with respect to third parties that are strangers to the judgment, there still is a legal significance on my client's rights. And the fact that the judgment exists, it's publicly available so everyone can see it. And under the statute, it attaches to the property, that's 9/1280, and affects the alienation, that's 9/1288. That I read that to be a form of execution. And I think that they talk about the plaintiff in execution. I think that's another way of saying judgment creditor. They don't use the word judgment creditor in the statute. So I think that if they said that you needed to file a FIFE, it would have said, unless they file a FIFE. That's not what the statute says. It says that if there's an execution, which is I think could be read to encompass the entry of a judgment and the effects that has, then we squarely qualify under the statute. And I'll again point out that the magistrate judges agree with our position. I think the equities of the case support it because we're positioned the same way as somebody that had a FIFE entered against them would be. I think that you read the statute in a way that reflects the reality of the situation, and I think that's why it supports our reading of it.
Okay. My last question, Mr. Weiss, and then I feel like we've beaten this horse pretty well to death today, at least as far as we're going to, is I asked you about the timing of the attorney's fees, and I want to follow up on that briefly because I understand that your argument is that the statute authorizes an independent action to recover damages or to do so inside this lawsuit. And the first real involvement you have with that is when you reach out to the court and ask us to reopen the case. And I guess one question I have is, even though, as I said a moment ago to Mr. Farron, right, we're talking about nominal damages, right, even at capped at 500, why in the world would it be reasonable to expend $12,000 to recover 500, right? Or put a little differently, why in the world would anything after the judgment was satisfied be reasonable attorney's fee, right?
My client was harmed by the violation of the statute, and notwithstanding the cap, and the cap is what it is. I wish there wasn't a $500 cap and we could go after all $15,000.
Well, the legislature's in session. You could go ask them to change it. It won't help your client, but
yeah, they got enough on their plate. But look, I think that my client wanted to vindicate his rights. I mean, you could come back and say, maybe some portion of this, I don't want to do all 12,000, but like I think that much of it, we did not overbid. I mean, look, my rates are what they are.
Let me
It's
stop you
published,
there.
like-
You do not need to justify that. I'm certain that if and when I ever engage in the activity of reviewing your billing, that I will see a reasonable hourly rate, well-qualified attorney doing work that is necessary for the vindication of the right. That's not really my question. My question is, in what universe is it reasonable to spend $12,000 for the principal? Because most of the time as lawyers, when people say it's the principal, it's not really the principal.
I think my client felt that his rights needed to be vindicated here. And I think all we did was file the motion and file a reply brief and appear for this hearing. Like there's nothing else that we did. I mean, I could go back. I mean, if you're focused on fees incurred prior to May 2024, which would have been like from November through May, there are some probably additional fees. I read the statute the opposite of the way you did it, and I thought it really was all fees relating to the bringing of the motion arising after the failure to meet, or once the judgment was satisfied. So that's why we start in May 2024 from the documents that were attached to the affidavit. So I think that whatever the interpretation is, I think you're entitled to get your attorney's fees to vindicate your rights. I'm not saying it's an unlimited dollar amount, but the bringing of the motion and the defending of the motion and coming to court, that I am certain was contemplated under the statute. It couldn't just be your attorney's fees relating to getting to the point where they satisfy the judgment. That's not how I read the statute.
Okay. And you're probably not wrong. I think where I'm getting held up in terms of understanding the application and intention of the statute for its language and also how to apply it is that if the purpose of it is to encourage plaintiffs in execution to properly file judgment satisfactions of judgment, then how does allowing someone to rack up $12,000 worth of attorney's fees to after the fact of the satisfaction of the judgment recover $500? How does that serve the purpose of the statute? And that's a rhetorical statement, but that's the part of what I'm looking at. I don't question that the work that you did was necessary to vindicate what you've presented, right? It's really a larger issue of whether or not the statute applies, and if it does, whether or not the attorney's fees are reasonable. So here's what I'm gonna do. We are done for today. What my intention is to provide you with a ruling or an order that says either the statute applies to the Eblers in this context or it does not, right? And if it does not apply, then I'm going to deny your motion, and that'll be the end of that. And there's no reason for me to get into the weeds of how much in damages Mr. Ebler might be entitled to recover. If I decide that the statute could be interpreted to apply to Mr. Ebler, then as much as I hate to run up more time, effort, and energy, I'm going to need affidavits or testimony or something from Mr. Ebler regarding the actual damages. And that, I think, would be the piece that would require a little bit more work, because I think already in the record, I have attorney's fees records, right? In terms of the attorney's fees that Mr. Weiss has incurred. And I think the law in Georgia is pretty clear that the court is an expert on what is reasonable and what is not. And to the extent that he has submitted an affidavit, you, Mr. Farron, could also submit an affidavit if you wanted to challenge the individual particular entries or the overall qualifications or the hourly rate, that typical stuff. But really what it boils down to is, if the statute applies, are there any damages? Because if there aren't any damages, then there would be no recovery of attorney's fees. And if there are damages, then I would have to get to the attorney's fees, though I'm not sure we would need an evidentiary component on that, because again, the lawyers can state in their place and provide the court with affidavits. That's sort of where I intend to leave it. I don't intend to leave this for long in terms of giving you an answer to the threshold question. But that is where I intend to leave it today. Is there any question, concern, thoughts, etc., about where we're leaving this case and what will be next steps or what you can expect before we adjourn for the day? Mr. Weiss?
The only thing I'll mention is you said if you determine the statute applies, then you have to determine if there are any damages. I think statutorily there are at least $100 of damages. So there would be some damages finding if you determine the statute applies.
I will take a look at that.
I understand what you're saying.
But I don't mean to question what you're representing to me, and I certainly am not implying that what Mr. Ebler has represented to you and what you are communicating to me is untrue, but it's not the same type of information that I would take at face value, that in fact there was a listing or an effort to sell that was impeded. In other words, there is a universe in which I say this does apply, and the judgment wasn't filed. The satisfaction rather was not filed, and it should have been. And what I have to go look at the statute, Mr. Weiss, to your point, is that automatic? Is that $100 automatic, or is it subject to proof? And I think it's subject to proof, even if the cap is $500. And so that's where we're going to leave that. But I understand your point, and thank you for flagging it for me, because I will go and look. Because if I read the statute and it is automatic, right? If it is not subject to proof that there is some minimum recovery, then that would be a different way for me to analyze it. You're right. Anything else, Mr. Weiss?
No, Your Honor.
Mr. Farron?
Yeah, Your Honor. So interesting point about the $100 presumption. My sense is that there may be yet another novel legal issue, which is is the presumption susceptible to being rebutted? Because it doesn't say that if in other words, it's not a strict liability fixed sum awarded. It's a presumption of damage. So, but in any event, the other concern I have is I may have expressed. You've seen this case for a few years. I've been in this case now for 7 years. The lawsuit was filed originally in 2019, and we have been in a lot of litigation, and I'm looking for any end to this matter. And so I guess my simple exhortation to the court in that regard would be help us end this case economically and efficiently for us and for you, Your Honor. And the comment I have about the attorney's fees, if there isn't a proportionality requirement, then this case, then the rule could become a cottage industry for filing lawsuits on late executions or late satisfactions just to basically generate fees. I'm not suggesting at all that's what Mr. Wise is doing here, but that's the moral hazard, I think, from a you're entitled to all fees without any check on.
Or maybe it won't create a cottage industry. Maybe it will do what it was intended to do, which is motivate people to timely file their satisfactions of judgment. Here's the thing.
Yeah.
I understand your request, Mr. Farron. I suspect that if I say this statute does not apply, no recovery for Mr. Ebler, or if I say preliminarily the statute does apply and Mr. Ebler might be able to recover, that the dollar signs that everybody will start seeing in terms of what will be required to demonstrate an evidentiary basis for either proof of damages or rebutting damages under a presumption, everybody ought to start seeing dollar signs and figure out how to get real reasonable. We're talking about, as I understand it, a $250,000+ judgment that was ultimately satisfied 3 years ago. It's over. Feels like this could probably be worked out in some way that everybody could live with. But I could be wrong. My hope is, and that is not why I divided it into two pieces. I divided it into two pieces because practically I think that's the way it needs to be done. But my hope is that once I give you that preliminary ruling about the applicability of the statute or not, that y'all might be able to get realistic about whether this case should be resolved or not. So that's my hope. Hope springs eternal, as they say. But this matter is adjourned. I only have one other question. Mr. McWilliams, I almost hesitate to ask, but there just aren't that many McWilliams in Georgia law. Are you associated with Kendrick McWilliams at all?
I am not.
Okay.
I do not know Kendrick McWilliams.
Okay.
I
Kendrick
formerly
and I go
practiced-
way back to law school.
Okay.
And so I was just like, there's only like 6 McWilliams lawyers in the whole state. And so I was like, I wonder if they're related. So
Yeah, I entered Georgia from New York, actually. I practiced at Fish and Richardson in Atlanta for 6 years.
okay. Well, I'm surprised you never got asked that question before because Kendrick is pretty well known. So in any event, it was nice to meet you. And I thank you all for your time. I will get you a ruling as soon as possible.
Thank
you, Judge.
Thank
Thank you, Your Honor.
Thanks, counsel.